believe he did some work for the Attorney General, although the Attorney General never tries as many cases as my office.
Want to talk
But different people are needed for different things. And the people of Fulton County elected me to make those decisions. And I know y'all want to come in and be daddy and create QAnon committees that will judge prosecutors and have these committees. But unfortunately for you, I won this vote by 68% this time, 87 in the Democratic, 68 the general, 72% last time. So the people of Fulton County have selected me to make these choices, and I make them. And my city and county are safer because I make them.
in the in your prior testimony with Miss Ashley Merchant, there was conversation around what she referred to as block billing. How would you describe block billing?
Oh, let's talk about Miss Merchant.
Let's just talk about block billing, please.
We're not.
I've opened the question to block billing.
The credibility of whoever's saying it is an issue.
Well, then let's just.
I'd like to talk about what this committee did the last time we were here, and for the press, I will have 50 copies of this so each person can get a copy. You all, the last time y'all had a committee meeting, you all purported this lie that I had the honor of meeting Vice President Kamala Harris. Me, oh, I'm going to answer this question right now. And when you stated that it was me and it was Mayor Dickens. And then you put this exhibit up for the entire world to see. How disingenuous, how lacking of integrity for Ms. Merchant as an attorney to put it up, and for Cowsert, who I noticed is cowardly not here, to have it here. This clearly says, I'm at a Black History Month project. Almost every important Black elected official across the country was invited to it. I'm on the lawn with a cocktail, and yet y'all tell the world I was sitting down with the vice president having a meeting. It was a damn lie. And this is evidence of it. And y'all had the audacity to put it up on the screen if you were doing something other than the DA was having a cocktail on the lawn. I have never even had the honor of meeting Vice President Kamala Harris. Never.
How would you define block billing?
Like somebody who didn't know what the hell they were talking about.
I'm going to refer you to the screen.
I don't review those documents, so you're asking me to look at documents that I haven't for the first time. What I can tell you is that I allowed Mr. Wade to bill 160 hours a week, and then Mr. Wade would be the first one in the office making sure that my staff arrived. He corrected their behavior. They thought that 8:30 meant 8:30. He taught them that 8:30 means 7:45. He got there before them. He left after him. He taught them how to do this case, and he was a leader to that team and a public servant. And for that, him like me has been threatened thousands of times. You want something to investigate as a legislature? Investigate how many times they've called me the N-word. Why don't you investigate that? Why don't you investigate them writing on my house? Why don't you investigate the fact that my house has been swatted? If you want something to do with your time that makes sense, and you can use all this in your campaign ad, you attacked Fani Willis. What have you done, sir? Nothing.
So I refer you to the screen. I know you said you don't approve.
I don't look at this. I've never seen it, so I can't talk to you about documents I don't approve and don't review. Can't talk to you about it.
Who does approve the documents in your office when invoices come in?
I thought we'd been through this.
I don't believe you said who reviews the invoices and approves the invoices in your office.
First of all, I have no firsthand knowledge of it.
You have no firsthand knowledge?
You want me to testify about something I don't have any firsthand knowledge of?
I'm asking.
Are you asking me to speculate? Because I clearly told you I don't have any firsthand knowledge of it, and I'm not going to speculate.
The question is, when an invoice comes into your office from a special assistant district attorney, what is the review process for that invoice before it's paid?
She's answered this. She said she has a deputy of operation, and he reviews or she reviews, and then it goes through the county. So it's a repetitive question.
What's the name of the deputy of operations?
The question has been asked and answered, and I believe it goes straight to the county, so I'm not sure. Dexter Bond.
Okay. Do you know who ATG may be initials within your office?
I don't.
I would assume it's accurate. That's probably not Dexter Bond.
I don't. It may be somebody at the county.
What we're looking at here are two bills that were paid by and approved by your department. The one on the left is from the Cross firm, which I refer to as Cross that we referenced earlier. The one on the right is invoice number 11 from Nathan Wade. And the first thing
Let me tell you why this is such a
the
damn
first
joke.
thing that jumps out to me as a non-lawyer, but as someone who has paid lawyer bills before, and I believe this gets to the question, the question which was around block billing. And here's my question for you, Madam DA. Are there rules in your contracts or otherwise when you hire independent contractors that gets to the billing methodology?
All right, ladies and gentlemen, can you hear my voice? Can you hear my voice?
Are they allowed to always bill to the even hour, or is there a professional expectation that they would bill to the 10th?
Let me tell you something. I had 3 attorneys working with me that had integrity. For you to insinuate that a judge that sat for 10 years and was the head of the magistrate court judges, that they did something illegal. They were underpaid. I have here documents where in one annual year, because I want you to remember his bills were over the course of 3 years. In one annual year, made $8 million, made $5 million. And I'm going to make sure that the press has that. So that when you're asking me about this great service to the state of Georgia, that it is understood that these are more than reasonable, actually bargain basement amounts. Ms. Cross would insist that I wrote government rate in her contract because she didn't want anyone to get confused that she would actually work for this rate, but for the fact that it was service to her community. So I don't know what we're talking about here, but to insinuate these 3 lawyers that have great integrity, have served this community well, did something unethical, I don't know why we're having this conversation.
I'm trying.
I don't know anything about the whatever you're talking about.
Okay, there's clearly some filibuster going on right now, ladies and gentlemen.
They hire those 25.
Madam DA is coming in hot.
We are the questioning here is relative to the approval process of invoices that are paid by your office. You have testified that that's done by Dexter Bond, that you're unaware of who the ATG is that signed off on this. We'll move on to this further line of questioning here.
You know, old men have to go to the bathroom about every hour.
Governor, would you like a 5-minute recess? We'll take a 5-minute recess.
Okay, ladies and gentlemen, this is going to be a long day. I am going to try to make sure I get you guys some B-roll from outside. This is happening right now at the Georgia Senate. This is expected to last probably until till probably about 3 or 4 o'clock. Right now, Madam DA is in control right now. She is in control of the narrative from this the onslaught of questioning. It's very colorful to say the least. And I want you guys to tell me, how do you think she's handling this? How do you think she's handling this? Do you think she's coming across as a bit defensive or adamant in her position? What do you think? Because she's going to pass some of the evidence in her folder to members of the press. And what we didn't know now, we know now what we didn't know then was she's alleging that attorney Ashley Merchant put up an exhibit at the previous hearing that was inaccurate, that purported that she had in fact met with Vice President Kamala Harris. And we now learned what we didn't know before is that she's never met Kamala Harris in person. Now, here's a problem for me. If you guys remember, Megan Thee Stallion performed in Atlanta, I believe. I believe she performed in Atlanta. She did perform in Atlanta. And the Kamala Harris, then candidate for president, was there. So I remember very distinctly that she wasn't at that event. So I wonder why she didn't show up. I don't know, ladies and gentlemen. This is going to get pretty intense. Actually, it's pretty intense right now. But let's just see how far this will go. Because right now, it does appear that she is attempting to control the hearing, and her attorney, former Governor Roy Barnes, is by her side and making sure that he provides her the necessary cover. I don't want to say cover, but we'll see. We'll see. So right now, there's a comfort break. There's an overflow room right now established, 2 doors down. And ladies and gentlemen, this is going to be interesting. Now, here's the other part to this. What do you think what she's saying today will happen down the road if the DOJ decide, because they're actually doing their own investigation? Do you think that this will put her in the crosshairs of the sitting president and his Department of Justice? What do you guys think? Because we do know that President Trump has went after New York State Attorney Letitia James, which that fell flat, as well as the former FBI Director James Comey. That too fell flat by way of court intervention and the higher court's intervention. So will he attempt to go after Madam DA as well? Don't know. But one thing's for certain, two things for sure. She is not letting them play with her today. She is not letting them play with her today. She said, listen, you can ask the question, but I'm going to answer the question the way I want to answer the question. And this is not, for those who are tuning in, this is not a judicial body where what she says I guess it can be, some things can be used against her, but there's no judges here. These senators, especially the one that is questioning her right now, is running for office as well. So that may pose a problem for him, because he may have an ulterior motive in doing what he's doing right now in the way he's asking her the questions. This is for those who may be shocked and say, hey, why is she acting like that? Well, we saw how she was handling the questions when she was in the Fulton County during the I guess the investigation as to the allegations that was brought by way of attorney Ashley Merchant and other attorneys who joined in on that in the hiring of Nathan Wade. Will Nathan Wade show up? Nathan Wade is nowhere in sight, and he'll likely not be present anytime today. But let's just see how she handles this. It's going to be pretty interesting, very colorful, and she ain't playing. She's letting them know, listen, you have the responsibility to make sure the district attorneys, not only in Atlanta, but all over Georgia, and making sure they have the resources so they can prosecute cases. Well, we'll see how this thing plays out. Ladies and gentlemen, stand by. Stand by. Okay, ladies and gentlemen, that photo is courtesy of yours truly. This is an image I shot, as well as shout out to all the other platforms that are that is using this and my other famous photo of the Madam DA Fani Willis. But yes, this is a photo I shot during the pre-trial of the former president and his co-defendants. In the background, you may see that. Okay, I think we see an attorney. That looks like the attorney in the background of that photo.
What I meant to
We're
speak
back,
is
ladies and gentlemen.
160 a month. Also, I have referred several times to the rates of the AG. I would like you to know that in 2020, the Attorney General of this state paid $52,000 in attorney's fees. I've done initial 52 million in attorney's fees with the top recipient in the year, AF. I've taken 52,000 in attorney's fees. I've done initial 52 million in attorney fees with the top recipient that year, initials AF. I've taken off their name at 3,593,000. That was for 2020. In 2021, again, in excess of 52 million, with the top one in that year being AD as the initials, 2,673,000. I should note the Josh Belafonte was one of the recipients that year, and he made 1.3 million in 2021. In 2022, the AG's office spent on special prosecutors $55 million. DS being the top recipient for that year,
I think
$2 million, 200,000. Josh Belafonte made $911,000. In 2023, the AG's office spent $65 million with the top recipient making $5 million, initials MR, and I'm going to finish. And 2024, the top recipient was MR, and they made $4.6 million. And then let's not leave off 2020.
All right, we're going to move on to the next question here.
Dollars by the AG on special prosecutors, with the top recipient MR making $8,181,421,000. And y'all are talking to me about pennies.
Right,
and I have a copy for the press 50 if you like them.
Yes, we want a copy.
All right, we're going to move on to our next question here.
And it is relevant since you're questioning the rate of the special prosecutor.
That's for the press.
All right, I want to refer your attention to the screen. Madam D, have you seen this letter before?
It's got my signature on it.
Do you have seen this letter before?
Yes, that's how it got signed.
You sent this letter on December 17th, 2021, requesting access to documents to from the January 6th committee, Chairman Mr. Representative Thompson. Is that correct?
I did.
Okay. Did you or anyone in your office receive help in your investigation from the January 6th commission?
Do you want me?
What do you mean by help?
Did they send you documents?
Well, they're public documents now.
Did they send you any documents that were not public? That were not public at the time?
None that I can recall. None that I can recall.
In the letter, you offer to meet them in person. Did they take you up on the offer to meet in person?
I've never met Thompson.
Have you ever met anyone that was doing work with the January 6th commission?
Not to my knowledge. I may have met them and not known they were doing that work.
Mr. Wade traveled to DC with members of your staff. Is that correct?
That is correct.
And Mr. Wade billed for conference calls with the January 6th committee. Is that correct?
Haven't looked at the bills.
What difference does that make?
On the left side of the screen here, and I apologize, the camera's in your way. There's a screen over here.
You have to remember the criminals that
Yes,
I
sir, I can
indicted,
see.
they had committed crimes all over the country. And so as a result, as a prosecutor, if you know that a criminal has done crimes in this state and other states, it would almost not be due diligence to try to get information from them. Here goes some more legislation you can take up. There is a process called TUI with the federal government where state prosecutors try to get information from federal prosecutors. They are not very helpful.
On this bill, on the left-hand side, the first
I
red
haven't
highlight.
seen the bill, so you remember?
That's why I'm showing it to you, Madam DA. It says team meeting conference with January 6th, research legal issues to prep and then it ends with V. He testified, and the testimonies on the right side of the screen that meant interview. And then the second one is travel out of state, interview and research, which was from April 27th until April 29th. Are you aware of a trip that Mr. Wade took out of state that your office paid for in April of 2022?
Yes.
What was the purpose of the trip?
I don't recall.
Okay.
I'm sure to get information on some of the criminals I ended up indicting.
This slide here shows essentially a reimbursement request on the right-hand side for Mr. Wade at the Hyatt Place Hotel. And on the left-hand side, this is an invoice for the Hyatt Place Hotel during the time period I referenced earlier for Mr. Michael Hill. Do you know who Michael Hill is?
He was an assistant chief when he left my office. He's an investigator, though, a sworn law enforcement officer.
And he was on your staff during April of 2022? You said when he left your office. When did he leave the office?
I don't remember. But yes to the first question. He was on my staff at that time. I don't remember to the second question of when did he leave. Not long ago, he got a higher title at another office.
Do you know who else from your office attended this trip?
I can't recall. You can refresh my recollection if you like.
This is an invoice for the same hotel on the same dates from Mr. Francis. I assume it's Mr. Wakeford. Is that someone that worked in your staff?
An amazing attorney.
What was his role?
He's an attorney.
What work did he do within your department, your team?
He does all types of work, but he is what I would consider to be an appellate lawyer.
Did he do work on the elections interference case?
Absolutely.
What work did he do on the election interference case?
He did a lot of excellent writing.
This slide here is for Mr. John Wooten, same hotel, same dates, same trip to DC. Do you know John Wooten
He works for me.
currently?
Yes.
What was his role in April of 2022?
A lawyer, works for my office, does a lot of white collar crime for me.
Did work on the election interference case?
Yep.
Okay. So is it safe to assume
That would be
from
Will
both
Wooten.
the testimony I had on the screen,
Will Wooten.
your letter, and Mr. Wade's invoices that reference January 6th, is it safe to assume that Mr. Wade and other members of your staff went to DC in furtherance of your investigation of the 2022 election? Or sorry, 2020 election.
I'm not going to make assumptions under oath.
You are unaware of whether or not members of your staff, 4 of them that we have here so far, or 3 and 1 independent contractor, you're unaware as to whether or not the purpose of their DC trip was to meet with the January 6th committee or members of the January 6th committee or lawyers working for the J6 committee.
I know that they went to DC, and I know it was in reference to this investigation. I do not recall who they spoke with, but you all have tried to make this some nefarious thing that lawyers would try to investigate and find out information about people who came to Georgia and committed crimes. And instead of being honorable in trying to defend those people that you take an oath to serve, we're here with this foolishness.
Do you know how many trips Mr. Wade took to DC
In his life,
as it relates to the J6 committee or the 2020 elections interference case?
I believe one, but I don't know. It's speculation.
Well, it wouldn't be speculation if he told you about it. Did he tell you about any other trips that he took?
But what you have to remember is it is whatever day it is in December of 2025, and I'm an office that prosecutes 64,000 people, and I know you are somewhat offended that I had the audacity to prosecute, these folks that came into my county and committed crimes, but this wasn't special to me. This was another day of business.
Ooh, the burn.
On the screen is another invoice from Mr. Wade, the highlighted section. I'll just read it out loud. It says January 6th meeting and ATTY Conf. That's from November 16th of 2022. And then there's a second entry immediately below that, interview with DC/White House, November 18, 2022. Have you seen this bill?
No.
Are you aware of phone calls or conferences that Mr. Wade either attended or was a part in that relates to the J6 committee or the election interference case, working with the J6 committee that is separate from the April trip that we just discussed?
We didn't do much work with a J6 committee, so I've never seen this bill before. And I believe the only thing that we called the White House about was, did we have to go through the TUI process with that White House like we have to do with the Department of Justice? That's my recollection. That could be right or wrong, but we were trying to speak to people in the Trump administration, the first one. So I don't believe we had a lot of contact with the White House. So I'm not aware.
You said you were trying to speak with people that were part of the first Trump administration in travels to DC, or are you saying that more generally?
More generally.
Okay. And just to clarify, I want to make sure that I have the record correct here. You're unaware of who Mr. Wade.
I can't
and the
recall
others
those level of details. I know you want to take me back to 1948, where an African American prosecutor can only prosecute certain types of people, but I prosecute and stand up for all victims that come into my circuit.
When was the special purpose grand jury impaneled?
I don't remember the date, but that's an interesting point. 2 grand juries said these people did these crimes.
The date that I have
And
is
the grand jury was made up of independents, Democrats, Republicans.
the date that I have is January 24th of 2022. Does that seem like it's within the range of being the correct date?
So I already stated I don't trust you. I understand you're trying to run for lieutenant governor right now. Anything you want me to testify to, I'm going to need to see.
Okay. Were you aware that in between the time of the special grand jury being sworn in and receiving evidence, Mr. Wade traveled to Athens, Georgia to meet with officials from the White House counsel's office?
I don't recall.
On the right-hand side here is the meeting that I reference. A highlighted section reads, travel to Athens, conf with White House.
How does this
counsel.
assist you in developing laws for Georgia? Because I believe the purpose that I'm here for is because you all need assistance in doing your job, and you want assistance with rules and regulations around how people should be a prosecutor. And it made sense to me that you'd come to the best prosecutor in the state to ask for some advice. But I'm confused as to how this assists you and what the purpose of me being here is.
The committee has a broad purpose. I'd be happy to refer to counsel as to the overall purpose of the committee. But my question for you is, as it relates
I
to
don't
this
think it's
travel-
relevant, so I'm objecting on relevance.
She's asked and answered that. She's told you that the TUI process goes through the White House counsel's office. She's asked, it's been asked and answered.
And it's your testimony today that the travel to Athens, conference with the White House counsel, as far as you were aware, was due to a part of this TUI process that the governor's referencing.
I've testified. I don't recall anything about this.
Okay.
And I don't see how it's relevant to what your alleged purpose is. Now, your real purpose is to try to get elected, which I would say, Georgia, please, let's elect any lieutenant governor but this one.
We'll get to your work trying to elect lieutenant governors in a second, Madam DA. But for now, we're talking about
I've done no
travel
work with
to
an
DC.
elected governor, but if I will do some work with this, I see that Counselor left you
contract.
alone today,
I'm not,
and he is running to be Attorney General of this state.
Madam DA.
And
we're
he
gonna
is
answer the
not
question.
qualified to be such. By record, by this document where he put up a false document trying to prove that I met with the vice president. That shows you he does not have ethics. But there is somebody running for attorney general that has been a state prosecutor, a federal prosecutor, a civil rights attorney, and a state's legislature. So if people want to vote for people that are ethical and actually have the experience to do the job, I say donate now to Tanya Miller.
Now, Dee, I'd asked you about Mr. Wade. Did you speak with anyone that had worked with the January 6th committee or was a lawyer for the J6 committee?
That's been asked and answered. She said she'd never done it herself. That's what she testified.
Did you communicate with members of the J6 committee through any intermediaries that relayed messages back and forth on your behalf?
I don't recall ever speaking to anyone of the January 6th committee. What you asked me, though, is have I ever met someone? I am a public official. I meet people all over this country all the time. Shake hands, take pictures, kiss babies, all the things elected officials do. So I have no idea if I've ever met someone that may have been part of the January 6th committee.
And I want, what is J6? Is that where they stormed the Capitol
And killed a police officer?
Is that the same committee we're talking about? So that it's clear on the record.
The ones that have been exonerated, we say that we stand with law enforcement, but don't care when police officers get killed.
We're going to continue on to the next question. Governor, you are here to advise your counsel. You're not here to pontificate. Absolutely.
Absolutely.
And
Everything that you're trying to say.
how does this help you for laws? Yes, I'm sorry, Judge. I'm sorry, Governor.
If you've got something to ask it, but don't go into, well, there must have been a conspiracy here when they went up and looked into the folks that broke into the Capitol in shamu suits or whatever that was, and put the Vice President of the United States out saying, hang Mike Pence, and that they were prosecuted and then pardoned by President Trump, and you're trying to say and infer that it was illegal, immoral to investigate that it was part of a pending case. So
We're asking questions relative to the investigation, Governor. We're going to move on to the next question.
you're trying to infer some wrongdoing where none exists. Ask the question, let's move on.
Thank you for
Also to divide this
Governor.
country, and it should be noted that there
we're
were
gonna move on to the
many
next
great,
question.
honorable Republicans that brought this case to me because they knew what happened was wrong. One of them is Duncan, who's now running for governor.
So you have your endorsement.
I didn't endorse him.
Wait just a minute, don't answer that question.
So
But I do think it should be noted that although you are trying to divide this country, that this country is not divided. Most people in this country are trying to do the right thing every day as they get up for work. Most people know when someone is murdered and victimized, you don't act as a depraved human being and tease them and their family in their greatest time of loss. Most people.
So I want to talk about a little bit of a timeline as it relates to DC and just a layout of fact pattern here, and then I'll ask you a couple questions. On November 9th, then President Biden stated and was asked about President Trump returning to office, and he stated that we just have to demonstrate that he will not take power. If he does run, making sure he, under legitimate efforts of our Constitution, does not become next president again. Are you familiar with that quotation from the president?
It has nothing to do with this inquiry. If you want to subpoena President Biden, subpoena him down here. I'll come. I might even represent him. He's got a fee. I hope he's got something left. We're getting mighty thin.
So a couple of days after this, President Trump did indeed announce that he was running for president. As you can see on the date there, November 15th, 2022. And then the very next day, and we've referenced this a second ago, but we're going to go back to it.
This helps you
The ve- the
develop
very next
legislation.
day-
How?
The very next day, there was a conversation between Mr. Wade. I'm sorry, there was an 8-hour, was described here as an interview with DC and the White House.
Interview with who?
It reads interview DC/White House. It's
And this
it's on the screen.
Answered, they said that they had.
And I'm laying a foundation here, Governor.
Don't answer yet. Let me listen to the question.
On November 18th, the very same day as this 8-hour phone call with the White House, U.S. Attorney General Merrick Garland appointed Special Counsel Jack Smith. And around that same period of time, some news reports say the same day, but we know within 2 weeks of that time, Matthew Colangelo, who is the former third highest ranking official at DOJ, tendered his resignation to take a position in the Manhattan prosecutor's office, which would go on to also indict President Trump.
He committed crimes a lot of places.
And convicted by the jury of his peers.
And you
So-
know, you
so
all
on
want to,
November-
no,
on
this is
November-
very
on
important.
November
You all want to intimidate people from doing the right thing.
On-
And you think that you're going to intimidate me. You all have been trying to intimidate me for 5 years, which is why I have not been able to live in my house for 5 years, because the N-word has been written on my house. Thousands of threats have come to my office. And instead of doing some legislation,
Madam
when
Chair,
someone,
just
no,
to
no, no,
get
when
you here
someone
just
says
before
something
the committee.
inflammatory that you know is going to cause them to be the victims of crime, you ought to do something about it. But you see, I'm not Marjorie Taylor Greene. I ain't gonna quit in a month because somebody threatens me. I took an oath to do the right thing. People came into my community and committed a crime, and I indicted them. And rest assured, if someone else comes in my community and commits a crime, I will indict them again.
The Special Purpose Grand Jury released its report just under a month after this time frame on December 15th of
And said
2022.
39 people should
Is
be
that-
indicted, but in my discretion and looking at the evidence that was the most damning, I chose to only present an indictment to the grand jury of 19. And who knew? The citizens of Fulton County, Republicans, Democrats, Independents, non-politicals, all said these 19 people deserve to be indicted, and they were.
The question was, the Special Purpose Grand Jury released its report just under a month after this phone call between Mr. Wade and the White House. Just a month after, on the very same day, Jack Smith was appointed by Merrick Garland, and just a month after, the third-ranking member of the Department of Justice left the Department of Justice to go work for Alvin Bragg. That date being December 15th, 2022. Is that the date that the Special Purpose Grand Jury released its report?
I don't recall.
Yes, don't answer that. And let me tell you. something.
You don't recall? Does that?
She said she did not recall. And to try to, everybody's a crook in your mind. Jack Smith.
Well, there were some crooks.
Well, I know, but
They were on the indictment.
So you reference your prosecutorial discretion and bringing these charges. I believe you say 50. You were talking kind of fast there. Was it 50 that you
I
said?
said that the grand jury recommended that 19 people be indicted. It's there. It's part of public record. What I did was look at all of the evidence against each of those persons, and I chose to only put forth an indictment that talked about the 19 most culpable. Those 19 were presented to a grand jury.
I just want to
That
clarify.
grand
You said 19
jury-
twice. I just want to clarify your testimony.
19 people were indicted.
Originally, how many were recommended? You said 19 for both. of those.
39
Okay.
were recommended, 19 were presented.
How many of the electors? There were 16 electors here in the Capitol that cast votes for President Trump. Is that correct?
I object. They were not electors.
There were
You
16.
talking about the fake electors that y'all sat in a hearing and listened to, many of y'all?
In this same room.
I was not in the room. But I'm referencing there were 16 electors who took part in that meeting. Is that your understanding?
Why are you not offended that people came before you and lied?
Were there 16? Were there 16
I
electors?
don't remember. I don't remember.
Okay. How many did you indict?
What does this have to do with you developing legislation? Because this is not relevant. So I'm going to object relevance.
Where are we going? I thought this was supposed to be.
I thought y'all needed some help.
It was supposed to be about rules of conduct. And so now you're getting into where the electors met here and they weren't really electors. And how many of them got indicted? Why did you do that?
We're for far more.
Wait just a minute.
We're here for far more than rules of conduct.
On why she chose to do so. It was presented to two grand juries. They returned an indictment on one because the investigative grand jury cannot indict, it can only investigate. And so, how is this to do with the conduct and legislation? I'm amazed that everybody's fixated that the election was fixed 5 years ago.
We'll come back to this. We'll move on for a second.
Let's move on for a good bit, maybe a half hour.
Well, we'll see what you think of this next line of questioning, Governor. In January of 2021, you referenced his name earlier, but you hired Jeff DeSantis to be the Deputy District Attorney overseeing the Media Relations Unit of the District Attorney's Office. Is that correct?
And strategy.
Media Relations and Strategy. Can you describe the difference between those two separate roles, or are you just saying that's the title?
That's the title.
It's the title. Okay. Was he serving in your office in April of 2021?
Yes.
Okay. He's classified those in ADA for personnel purposes.
He is a lawyer.
Yes,
He went
he
to
works.
Emory Law School. Was there 2 years ahead of me and graduated. He's my elder.
That's not hard for me.
When you're referencing media relations, how would you describe the overall role of media relations?
This has nothing, I don't read about media relations in any of these resolutions. It's beyond the scope.
This is within the scope of the state's funding to that department.
Not
To
a
the-
question about who's the director of media relations.
I'm asking what the role of media relations is.
Neither is that. Don't answer. I instruct you not to answer. Completely irrelevant.
Your objection is relevance.
No, my objection is the reason she hired and the reason that she has hires and fires employees and the reason that she undertakes to run her office is a matter of employees, which is exempted and is privileged and is a deliberative process.
So you are asserting that the role of a media relations director is privileged.
You can move on.
You want clarity on that, Counselor?
So you're instructing the witness
I'm
not to
gonna-
answer on
I'm
the ground of relevance?
instructing.
I'm not arguing with you. I'm just trying to understand what the objection
I stated my
is.
objection. Where's the court report? Here's the court report.
It would help if, Governor, respectfully, it would help if the objections could be limited to like 5 to 10 seconds. I mean, I don't need a speaking objection.
I talk slow.
I'll give you 30 seconds, but it's counted by words,
I'm
Governor.
a country lawyer, and it's real hard for me to get things done. It is beyond the scope of the resolution, number
Okay.
one.
All right, can we break and address that?
I'm gonna say my objection. I mean, I'm not here-
That's fine, we'll do it all together.
I'm not here-
I'm just trying to understand.
I'm not-
I'm not trying to debate,
I
Governor.
think he's just looking for clarity on your objection, Governor.
It's beyond the scope.
Okay.
It's irrelevant. And the decisions she makes on personnel are not subject to inquiry.
All right, on the beyond the scope, I'm sorry. Oh, I can do that, I guess. Is that me?
It's on.
Oh, it's on?
Yep.
Okay.
Can you hear?
I know I'm not going to convince you, but I just want to give you the chance. I certainly know I'm not going to convince you, Madam
No,
DA.
you're not interested.
Whereas this is lines 26 to 30 of Senate Resolution 5. Whereas many have concluded that the conduct of District Attorney Willis has brought her and her office into disrepute.
My office has brought myself into respect.
Ma'am, I'm sorry. I'm, s-
And so that is,
I'm not done, Governor.
okay, go ahead.
Undermine public confidence in fair, impartial, and
The public voted me again by 68% respect.
Madam DA, I don't think that it's, well, you continued. I mean, I've got my second fundraiser email from you while we're sitting here.
Did you donate?
Impartial. I did early on when you ran against Paul Howard, and you know that.
You selected the best DA in the country.
I'm just here as a lawyer, man. Fair and impartial, disinterested administration of justice by prosecutors across our state and cast significant doubt as to the purpose and validity of the charges of her office has brought in regard to the 2020 presidential election. Further, when you get to the language, the actionable language under powers and duties of the committee, The committee is hereby reauthorized to undertake legislative investigation into the issues mentioned above or related thereto. So I would submit it's broad. I presume that doesn't change your position, but I just, okay. You say that it is irrelevant. You mentioned at the start of this that you were going to be able to object to privilege. Is it your position that relevance is a privilege that you're asserting?
It's more than just privilege. It is also that it's beyond the scope. And what you've read me there is just confirmed that it's beyond the scope.
Or related thereto when it speaks to.
Related thereto refers to the 2020 election.
Correct. And both you and Madam DA have said that her decision to bring the case and how it was brought and who was brought against, the exact things the Court of Appeals talked about as initial pretrial decisions,
Correct.
caused people to question and the fairness and of justice. And so if that is what the courts have said, not me, I'm not here to say one way or the other, but if that's what the courts have said, and that is in the language of the Senate resolution, your position is that it is limited to what?
It certainly does not encompass who the press secretary is in the DA's.
Okay, but the question that was on the floor was, what is the role of a media relations person?
What his role would be.
Fine.
How does that got anything to do?
I think the question was, and if you need, I'm sure it could be asked this way, is what is the role of the person? And so to that question, which does not include any individual, but what is the role of the office? The objection is scope and privilege, or scope and relevance.
Correct.
Okay.
And also personality.
And since you mentioned fundraising, I'd like to make sure that this is part of the record. Counselor believing he's going to go after Fani Willis and asking to donate at the last period. I also have 50 of these for the press because this is about folks sitting here trying to get elected.
Do we have anything else?
We do have a lot more, Governor. We'll take a lunch break just so you all are aware if you want to make arrangements at 12:30.
I'd like to go straight through.
We'll take a lunch break at 12:30. Madam DA, relative to your full-time employed staff, such as Mr. DeSantis, what rules, if any, exist relative to other work that they can do, either contract work or employment work outside of your office?
If it's an investigator and they're working a job, off-duty job, extra job, as most police officers do, the chief of investigations has to sign off on approving them for that work site, as well as the district attorney. So that is to the law enforcement that report to me because, I have a police department there. And so they have to get it signed off on that it's appropriate work. I don't like my investigators working in nightclubs, but they can certainly work at a store, or they like to work at State Farm Arena and things of that nature. If it's a professional that's not an investigator and not a lawyer, they're pretty much able to do whatever. Of course, they can't do it on my hours, but they can work whatever. And if it's a lawyer, prosecutors are not able to practice law doing that. If, they were selling pies at Christmas, I probably don't care.
Somewhere in between practicing law and selling pies, are there any restrictions besides that?
None that come to mind.
Okay. Are you aware of an entity called Critical Mention?
I am. I'm aware that you all use it.
What can you tell me about Critical Mention?
Critical Mention kind of tells you when your office or an issue that concerns your community comes into the new space. It has been used as a device by my office to find witnesses. It's been used as a device to determine if there's a pressing issue among my constituents that they are concerned about. But it is basically an outlet that lets you know what's going on in your community. It's helped us find witness victims and, like I said, been used for security.
Help me understand how it helps you find victims or find out what's happening in the community.
You would be surprised because people will complain about some issue. You won't know anything about it. Somebody got robbed. It brings cases to your attention because, I'm not a small prosecutor's office. I'm a huge prosecutor's office, and so it brings things to your attention. I can't give you more than that.
Are you aware of any other uses that your office uses critical mention for?
I don't know all the uses. I gave you some.
Okay. You sent a letter to Governor Kemp, Secretary of State Raffensperger, and Attorney General Carr. I believe it was essentially a records retention notice in early 2021. Is that correct?
That is correct.
Okay.
I didn't want anyone destroying evidence. Not that they would do so intentionally, but I didn't want them to do it unintentionally.
So on the screen is a report from Critical Mention that we referenced earlier. This report was in an email from Mr. DeSantis to you and someone who worked for you at the time. And this came the week after the time that the letter was sent. And the letter I just referenced to the governor, the AG, and the secretary. Mr. DeSantis's email states that the analytics graph is attached as PDF. The previous one I sent was for, quote, Fulton County District Attorney. This one is for, quote, Fani Willis. We're getting more coverage via your name than by title. This graph has the coverage value for the last week at over $150 million. That's obviously high, but even adjusting downward, it's still a huge number. And then what's highlighted in red here is part of the critical mention report that mentions, which I'm going to just assume how often the search, which I think that he said this one is for your first and last name, what the audience was, which was approximately 6.3 million people, and then publicity value, which I think is what Mr. DeSantis is referencing when he references coverage value at $150 million. Do you recall seeing this report?
I don't.
Do you recall critical mention being used at all within your office to track the value of media as it related to the coverage of the election interference case?
I told you she doesn't.
She told me she doesn't recognize this chart. I'm asking generally if she, this report, I'm asking if you've seen any report.
I don't know that I've seen any report, but I've definitely heard Mr. DeSantis say, that these numbers are always inflated. So yes, I've heard of it before, but you're asking me about a particular report.
Have you seen this page from a PowerPoint document before?
I've seen it. I don't recall it.
Okay, this was also sent by Mr. DeSantis to your email. And here this captures a broader range of time. The first one, I believe, was for just a couple of weeks. This captures essentially the first 11 months of 2021, at which point in time those audience impressions had grown from the previous number of 6 million, if I recall correctly. The publicity value on the last one that we looked at was 150 million. This one is $637 million. Do you recall seeing any other report that was tracking the publicity value of your name, your work, or your prosecutions?
I can never recall seeing a report. Does not mean I have not seen one. I do not recall seeing a report. But so that we're clear, I've heard Mr. DeSantis mention things that are along what you're talking about.
This is an email from Mr. DeSantis, dated around the same time frame as the first report, February 17th, and he's referencing now just the first search that he did, which was for Fulton County District Attorney. He lays out that name received $67 million, which he already said was more than your name. And he concludes his email by stating that even half of that value would be staggering.
Right. He doesn't believe the numbers. He thinks they're inflated. And that's kind of what I reference him
Sure.
talking, that he doesn't believe the numbers.
But he does believe that the value, whatever value, what value means, that we would all need to interpret there, but that even at half of the value, he believes that would be staggering.
You're asking me to speak on.
No, I'm just stating what I'm reading in the context here.
How does this help?
Well, now I'm going to ask you, as a public prosecutor,
Mhm.
why would media coverage and the earned media value, either for your title or your name, be relevant to your job as a prosecutor?
You'll have to ask somebody else, because I don't know the answer to what someone else is thinking. I do know that it has been very important to me, and it continues to be very important to me, that we are very transparent with our public about what we're doing, and that the media, when they're doing their job, it is important that they tell the public what the work is that we're doing, and that they tell them what the services are that we provide them, and that we are always here for them. So that is an important value. The first time, I don't want my constituency to see me, and this is something I say all the time, first time they get to know the Fulton County District Attorney shouldn't be when I'm locking up their nephew. That's not when it should happen. The first time they should see us is when we are out in the community doing service projects, whether that is I am in the schools. I am the only district attorney in the country that all year long I am in the schools with our children, making sure that we see them in the classrooms and not the courtroom. So that is me touching my students and their parents. The first time they see me is when I'm giving away book bags. The first time they see me is when we're doing Christmas drives or Thanksgiving drives. The first time they see us is so that they know that they are coming to an office that is a judgment-free zone. And I think it's why, and I have this for the media too, I have a 92% conviction rate this year. I tried more cases than any prosecutor in the state. That's the U.S. Attorney for the Northern District. That's the AG's office. My office is doing this work. We are keeping the community safe. Because I know y'all won't believe me. I brought a report here from the Atlanta Police Foundation talking about how crime is down in our community. And it's not the district attorney's office alone. It is the district attorney's office combined with the law enforcement in this community. See, I care about the police. So I don't excuse that an officer got killed on January the 6th. To me, it's a problem.
The question was, as a public prosecutor, why would media coverage be relevant to your role? And
I answered it.
I don't know that you did, and I want to clarify, because I think what you answered was why public relations are important to your role, and people seeing you before they get locked up and all that stuff you referenced, which I think is valid. My question is, there are multiple emails that are tracking in concurrency with your work in the election interference case.
With my concurrency in work, period. That's the work that you think is important. I've answered the question. It's asked and answered. We should move on.
The question that I'm asking you is not why are you doing public relations? I'm asking you, why are you tracking the dollar value of your name and your title?
And she has told you she does not know the report. She has told you that she has heard it discussed, but she does not know the details. She has told you that it's important to get a message out. And if that's not been asked and answered, I don't know what it is.
Governor, I certainly understand. I'm not asking about the outbound messaging. I'm asking about the inbound tracking of the dollar value. If you believe that we've covered that, we'll move on. This is the first payment for critical mention. That's a yearly subscription of $10,000. You told me earlier you've never seen a payment voucher form from Fulton County, so I would assume you've never seen what's on the bottom right. Is that correct?
I don't think we should assume, but you'd actually be correct.
Okay. I'm assuming that your testimony was correct earlier, and I'm tying it together to right now. The second time that critical mention was used, and we talked earlier about funds and accounts. This check was used to pay critical mention for their 2022 contract. Have you seen this check before?
Have I seen the check?
Yes, ma'am.
No.
Okay. What account is this from?
It was a Fulton County account. One of the accounts Paul left. So I can't answer you what account it's from. Whatever bank that's from, that's the account it's from.
Just to clarify, you're saying Paul, you're referencing former District Attorney Howard?
Yes, and you were absolutely correct. Former District Attorney, I believe it's from one of those accounts. But that's actually speculation too, but I assume that's what it's from.
Do you know how your name got on an account that was formerly used by District Attorney Howard?
Absolutely. At the beginning of my tenure, I had to go and switch names from that DA to this DA.
And part of that changing of names was changing this bank account.
Correct.
Okay. What is the source of funds for this bank account? I know when we talked earlier, you referenced essentially you get everything over the county. You don't have your own credit card. You don't have your own accounts. I want to clarify what this account is.
It was accounts that Paul left. There were a couple of them. At the beginning of my term, we put our name on those accounts. Me and District Attorney Howard did not have a conversation. He went to the bank, then I went to the bank, and we used it for things for the office. We've been audited 50 million times, so it's in some audit. There's no DA that's been audited as much as me.
Do you know how much money was in that account when you?
I can't recall any of those facts.
Do you know if you've allocated any additional funds in the time that you've been DA into this account?
I do not believe so. Brings me to an interesting point. We did not want to take in money, and I also wanted to have an office that was transparent. And so, in my first 4 years, the only way that a district attorney would take in money would be from open records. Well, I had this great idea as the new DA. I wanted the records of Fulton County DA's office to be equally accessible to the indigent and the rich. Many people abused that. And so I had to change it in term 2. I mention this because I didn't take any money during the first time for open records. And so there's no other reason that a DA would take money in that I can think of. If there is one, I'll have to be educated on it.
As it relates to this, well, let me ask this question. You referenced there was 2 or 3 other accounts?
There was a couple of accounts. We've been auditing all my audits. You know, once y'all started attacking me, they audited me every other week. There is no DA. I just passed a DOJ audit.
Do you recognize the signature on this check?
It looks like DB, Dexter Bond.
Dexter Bond, just for clarity, is your
Deputy of Operations. That's
Deputy
why
of
he would see these kind of things and I would not.
Do you know what the allowed or the restrictions around the allowed uses of this account, of which you
All money that we have has to be used for the betterment of my office.
and the only source of funds that you're aware of in this account, or it was money that was in the account when you signed it over from former district attorney?
That is correct.
Are you aware of anything else that has been paid for out of this
No.
account?
Let's make sure you understand me clearly so I don't. I'm sure other things have been paid for out of this. Your question was, am I aware of other things that have been paid for? I can't recall that from 2021 or 22 or any other year.
What's the reason that this account will be used versus the voucher system with the county that I've had up on the screen a couple of times so far this morning?
They would make us. I go to them if this is what I need done for the office. I don't make selections on what account is used. I don't even know what all those accounts are. I can't tell you that this account is the account that you can buy books out of. This is the account that you can do this out of. But I know they have those kind of delineations with the county. But I don't get that. You're in the weeds.
And it's your understanding that this account would have been something you referenced an audit. The state Senate's never done an audit.
Oh, I've been audited a millions. The county has audited me, the federal government, I have been audited and audited and audited.
And is it your understanding that this account would have been captured in an audit?
Absolutely.
Okay. I was asking you earlier about essentially what I'm just going to colloquially refer to as side work that is done by full-time staff within your office. And I believe that you told me essentially you're not micromanaging. There's no prohibition on side work. Is that correct?
Well, I told you specifically with my investigators, there is an absolute process. They cannot work as investigators or police officers because that is what they are. I think some people don't understand that in a district attorney's office, the investigators are sworn law enforcement officers with very great careers. It's something that a lot of them come to do after they've been police for many years. And we do have a sign-off process because I don't want my investigators to work at nightclubs. I know they pay a lot per hour, but I would prefer them not to do that kind of work, although I do allow them to do extra jobs.
Most recently, as it relates to I will call it the larger story of the case recently, that was a ruling relative to an appearance of impropriety on this case.
What are you talking about?
I'm talking about the appearance of impropriety that resulted in your disqualification from the case. Prior to that, your office was investigating the now Lieutenant Governor, was not Lieutenant Governor at the time, Burt Jones. Is that correct?
I don't understand the question.
Has your office ever conducted an investigation into then Senator or Lieutenant Governor Burt Jones as it relates to the election?
How does that help you with legislation?
Let me do my job.
Yes.
Don't answer it as part of the deliberative process and returning it and not investigating returning it.
Is it not a matter of public record, Governor?
Then why are you asking?
I'm laying a foundation I'm laying a foundation as you would call it.
Well, why don't you skip along to the question?
We're getting there. You're objecting to the
Deliberative process.
it's deliberative as to whether or not Lieutenant Governor Jones is part of an investigation.
It is deliberative because we know it was part of an investigation, and he was indicted by or recommended by one and by a second one. But the reason he was indicted.
I'm not asking for the reason he was indicted. So I believe that we can agree on the grounds that
Well,
Lieutenant.
what's the question?
The question is the degree to which Madam DA was aware that Jeff DeSantis, while he was serving in the office, was the registered agent for a business named Charlie Bailey for Georgia.
Okay.
What's your question?
My question is, are you aware that while he was employed by your office, Mr. DeSantis was serving as a registered agent and secretary of an entity called Charlie Bailey for Georgia?
I don't think I knew that until now. But Charlie Bailey, who's now head of the Democratic Party, I consider a great personal friend.
I heard that he was maybe in the Capitol today. I haven't had the opportunity to meet him yet.
He's a former DA, former assistant DA. Prosecutor Real.
Are you aware of any work that Mr. DeSantis did on Mr. Bailey's campaign
Nope.
when he ran for lieutenant governor or for, I believe this was for attorney general?
I'm not aware.
Are you aware of general campaign work that Mr. DeSantis is involved in?
I don't know. Am I aware that he's ever been involved in campaigns?
And while he's been working for your office, I'll clarify that.
No, I'm not sure that I do know that he's working for campaigns while employed for the office, but I certainly know that in a prior life that he did work on campaigns. He's like, as we get older, we tell war stories.
Let me ask you, what was the date on that? I can't see.
Well, it varies, Governor.
It says 2/1/2018, which would have been long before I was there, but then it says last annual registration year 2022. So I'm not sure at what point Mr. DeSantis did this. I'm not sure it tells what it purports to tell, but it's on the screen.
Well, he's a registered agent. Anybody can be a registered agent. Not be
Well, the secretary as well is what I was asking about, which is the role of an officer. The officer information is noted there at the bottom. Did you say you were a supporter of Mr. Bailey when he ran for attorney general?
I said that Mr. Bailey was a friend. I think that was a cute little question you asked. But what I said was that he was a good friend. He used to be an assistant district attorney that reported to me when he was a younger lawyer. I was his supervisor. If you know Attorney Bailey, he's a white male, probably around 40 years old now. And I just adore him and his family.
So you don't recall if you supported him for attorney general?
I would support Mr. Bailey in anything he does. He has great integrity. Anything he wants to do, I'm here to support him.
So you did support him when he ran for attorney general?
She didn't.
I'm trying to get to the core of the question here.
And tell me how we're investigating now because of this. If that's not beyond the scope, who you
Well, we know that Mr. Bailey there was a finding of conflict in this case, specifically relative to Mr. Bailey. I'm sure that part of that may have been to the campaign contributions that were made on behalf of the DA to Mr. Bailey, which is now on the screen. There was a fundraiser, I believe, that was the acute conflict that the judge recognized, and so that's what we're getting into. This is directly applicable to this case.
I don't find it relevant. But he's a friend, and I gave him some money when he was running.
and he used to work with me.
And I'm asking people to give Tanya Miller for Georgia some money so we can get a good attorney general in here. Not a corrupt one that puts false things on screens.
So Mr. Jones was a candidate for lieutenant governor. Is that correct?
It should be noted at the time of that ruling, which I still find to be ridiculous. Mr. Bailey was not running against Mr. Jones. He was running against Kwanzaa, and I can't remember his name. It was a Democratic race. But the ruling was found. I take exception with many of that judge's actions. But, I'll leave that for another day.
At the time of the fundraiser that you did, it was in a primary, and you knew that whoever
That's
was in
a
primary
great
runoff.
point. It was a primary. It was not a general. He was not running against Burt Jones. That was a fabrication of facts. He was running against Kwanzaa Hall. His name just came to me. You get older and you forget things, but he was running against Kwanzaa Hall, and I did a fundraiser for him. That is absolutely correct. And he need to give me some money back, 2,500. I needed contribution.
Mr. Jones moved to have you disqualified from the investigation based on your fundraiser. Is that correct?
Yes, and that's something else that I'd like y'all to take up as a legislative body. I think that when judges rule on things that are directly in the favor of legislatures, we should have a bar of when they can be appointed to the next bench, because I'm watching a lot of judges in my career do things in an effort to kind of say, pick me, get promoted. And I think that it would be some good legislation of this body and of the legislature to say that if a judge directly rules on something in the favor of any legislature, it should bar them from being promoted. That'd be some legislation, since y'all want some help with legislation.
And Judge McBurney granted the motion to Mr. Jones to have you disqualified. Is that correct?
Correct. And then surprise, Scandalakis has dismissed the case.
We're going to get to Scandalakis in just a second, but Judge McBurney said that it was, quote, a plain and actual and untenable conflict. Is that correct?
He did.
Okay. He described it, I believe, in oral commentary, and stated that he regarded the optics were horrific, described it as a what were you thinking moment.
The left circuit described McBurney as unethical. We're going to talk about, people pontificating. Is that what we're doing here?
We're going through the fact pattern of this case. And then, as you referenced, Mr. Peter Scandalakis, as head of PAC, continued the investigation after you were disqualified. He concluded the investigation did not further warrant further action after interviewing Mr. Jones 4 times and reading your entire file, among other things. Did you give your entire file?
Mr. Scandalakis has never read our entire file. When he just dismissed his case, there's no way that he read the entire file. There's no way that he reviewed all the evidence. It's no way that he interviewed witnesses. But as Counselor set up, shitting and grinning in front of the media, saying, "Oh, we know this case gonna be dismissed." I bet you do.
Are you familiar with a company called Canal Media Partners?
It's my fundraiser. I think that's the name of my fundraisers. No. Canal Media Partners is who I pay to do filming or something. It's somebody I pay.
On the screen, we've got your 2024 summary from the State Ethics Commission page, and Canal Media Partners is listed as the second highest paid expenditure of your successful DA campaign.
They do great commercials. Use them.
To the tune of $527,000. It's my understanding from looking at their website that they do media buying, among other things.
That's why I won by 87%.
And there's a gentleman by the name of Mr. Chris Hutman, who
is brilliant.
Does work for you. So you're familiar with Mr. Hutman?
He is brilliant.
What does Mr. Hutman do?
He buys media space. And if you're an elected official listening, you might want to hire him, because he is able to go and find you the best rate so that you can get the best media. So really the best bang for their buck. Don't mean this to be a commercial, but I did win by 87%. You might want to work with him.
His LinkedIn shows present work with or employment. It doesn't clarify either, but it shows that he's been at Canal, which we've talked about, for the last 13 years. And in a company called 2020 Insight LLC for the last 15 years. Are you familiar with a company called 2020 Insight?
It sounds familiar, but no. I might have paid him. I just don't remember.
According to 2020 Insight's current website, it is a partnership between, they don't say partnership here, but the state's under their Who Are We, it lists Mr. Jeff DeSantis and Chris Hutman, Mr. DeSantis being the same one that serves in your office, and Mr. Hutman being the gentleman that we just talked about that you referenced.
I don't know that he currently still works with him, but we could have got to that question 3 questions ago. I know at one point they worked with each other.
The website for saying that Mr. DeSantis is current, but it's your testimony today that you don't know whether he does work with 2020 Insight before.
I don't know that he actually continues to work with them, but I certainly know that in the past that he worked with him.
Is it your understanding that Mr. DeSantis and Mr. Hutman were business partners?
I really don't know what their professional relationship was, so I don't want to speculate. I will tell you this: the governor talked about old men having to go to the bathroom. 54-year-old women do as well, so we don't have to get me to a bathroom break.
We'll take 5.
Thank you.
We're going to reconvene. Thank you all for your time this morning. For those of you at home wondering why I've been the only one answering questions, the committee policy for the duration of this committee under the leadership of Chairman Cowsert has been that questions would come through the chair of the committee. And so that's what I've been doing so far this morning. And then in conjunction with that, any questions from the minority party would go through the minority leader or an individual designated by the minority leader. And Leader Jones is here. You've indicated you will be asking those questions on behalf of the minority party. And with that, I'm going to turn it over to Leader Jones.
And that has to be pretty brief. Hopefully we're near the end here. Madam DA, nice seeing you.
Good afternoon.
Good afternoon to you too. I do have one quick disagreement point with you.
Mhm.
As a fellow person from the MEAC, we all know that South Carolina State University is actually the university.
There always has to be a number 2.
And they won the
They did win the championship. Absolutely. I did have a question for you because I was wondering if I had the numbers correct. Did you say $80 million was spent by the AG's office in one period of year? on
In 1
outside
year,
counsel?
yes, sir.
Mhm.
I have this exhibit. You are welcome to it. It runs, and it's 80 million just for the special prosecutors. In 2025, it was 75,744,000. In 2025 to date, so the year is not over, they have spent 80,056,000. What we did was collect the 13 top people that received money, MR, because we didn't think it was necessary for people to know who they were, but you can get this off the made 8,181,000. The 13th person on the list, so everybody else is in between, made 1,050,000. This is in one annual year.
And I thank you. And thanks for clearing that up. I did have a question also about the block billing, and I know that you didn't really look at the bills, but just kind of asking from a standpoint of just, I guess, experience. It could also be just as reasonable that whoever was actually looking at the bills could say, look, I don't need every phone call. I don't need every witness name that you talk to. Just give it to me in one kind of block, and we do it that way. And by the same token, someone else could say, no, I want every single thing. And you just have a difference about how the person can input it into their particular system. Is that accurate?
Ms. Whitmore, who is the CFO for the county, is a stickler. If she paid a bill, it was done to whatever the county rules are. But again, you're asking me to speculate.
Yeah.
I never saw the bills. I don't see the invoices. And that's a good point of clarification. Several documents have been put up this morning. I can't attest to the accuracy of any of them. In fact, it is clear that some of them have been augmented, and they're not authenticated documents. So no document that's been shown here today has been authenticated, and it's clear that some of them have been altered. But whether they've been altered or haven't been altered, that was my first time seeing them.
In any event, however a person wants to get the billing or not, would you think that this is actually a good way for us to come up with a recommendation on how local DAs or solicitors should actually try to do their billing for outside counsel? That the Georgia General Assembly should decide this is how we should do our billing practices.
What I think is that the voters should elect ethical district attorneys, and that those district attorneys should do the things that are needed to make their communities safer. And that I always like the idea of, for me, I don't think it's necessary for every DA, but I liked that the county looked at our documents. I didn't have to do that. But I knew I was a Black DA. I knew I was the first woman DA. And so I took extra precautions because I understand what that means.
Absolutely. And you also want, I think, kind of clarify on this White House trip where you're saying you were actually on the lawn. I didn't know if you want to.
I was not at the White House.
Right.
And so that has been a lie that has been purported by members of this committee. That what happened is, I know we don't like to talk about Black history, right? We want to get rid of Black history museums. We want to get rid of, and I want to say this, we want to get rid of free admissions to parks on June 10th and on Martin Luther King's birthday. But I'll let you know something. I appreciate our president because he made free admissions to parks on my birthday. So I do appreciate that. Hopefully King Petty don't get rid of that day. But right now you can get into a federal park on my birthday for free. Now, with that being said, that was a party celebrating Black History Month. And I was so excited to get the invitation. And leaders from all across the country literally came to not the White House, because I never went to the White House on that trip, and I think I was there like 24 hours. It was at the vice president's house, but not actually at her house. It was in a tent on the lawn. Quite frankly, while we were there, I never got a chance even to meet the vice president, which was disappointing. I thought, you have all these people from all over the country there. You would like kind of do an assembly line and sign and, everybody take a picture, but that did not even occur. She did come on the stage at one point with her Secret Service all around her. I don't know what was going on, but Secret Service was all around her. But it was still a very valuable trip because I got to meet leaders from all over the country that were trying to service their communities. And so I was honored that I was thought to be a leader worthy of having an invitation to that event.
Thank you. And there was also a question about whether, Judge Wade had met with somebody from a January 6th committee and things of that nature. But let me ask you this, whether that took place or not, and there's a question about that, but whether that took place or not, would that have any relevance to the co-conspirators in this case who are going around from state to different states, making that stuff about the 2020 election and actually trying to do the things that they were trying to do in this case?
We based our case on what we investigated. And as someone from the South and as a Black woman, I've taken a lot of offense to this because there's been this indication that I'm not smart enough or people from the South aren't smart enough to be able to do this type of complex investigation. We did it. It was my team who did it. We did it all. And Dolezal, I hope that I pronounced your name right because I want Senator Dolezal, asked about ethics. I think he should know if we want a full picture of ethics that Judge McBurney, who he just mentioned, one of the fake electors threw him a fundraiser. So while we having facts, I want to make sure we get all the facts out here.
And when we're talking about also with, Judge Wade and billing and things of that nature, did that cause at all? I think the record would show that the vice president's personal attorney, based on what these conspirators actually were doing, actually called a former federal judge and said, you need to send out a tweet to say that Vice President Pence must actually certify this election because he was so concerned that there might be denied a certification coming January 6th. Anything about this billing have any impact on any of that kind of thing taking place at all?
Nothing about this billing can bring back the 5 lives that were lost on January 6th, to include, I understand that 4 were people that were in the mob, but they didn't deserve to lose their lives. One is very personal to me because it was a police officer just trying to serve. And here goes another example of a good American, and this is not about parties as you all have tried to make it. They tried to kill our Vice President Pence. Now, I probably have never agreed politically with anything Pence said, but what I do know is he has a right to do his job and to be free from harm. And we're trying to, we say we're not for violent crime, but we sure like violent criminals if it's helping our cause.
And we also talked about, what is it called? Critical measures? Or
Mentions,
critical mentions. So even discussing that, what critical mentions actually have anything to do with the fact that just yesterday, as a matter of fact, 2 former co-conspirators, because the case has been dismissed, I think Mr. Roman and Mr. Cheeseborough, just yesterday in Wisconsin, was held to answer charges, 4 felony charges for actually creating a fake elector program that was similar to what was prosecuted right here in Georgia, that they're going to be felony charges facing those. And there were 2 conspirators in this particular case who had the same kind of scheme. Anything about his billing or anything about critical mentions have anything to do with the fact that 2 persons that were indicted in your case, right now, just yesterday, a judge in Wisconsin said, you're going to face charges, 11 charges, based on similar scheme that took place in Georgia.
No, and it should be noted that Roman was indicted in 3 separate states and that many of the co-defendants were indicted in separate states because, and let's be clear so the record is clear, in my indictment in Arizona, they indicted John Eastman, Gina Ellis, Ruben Giuliani, Mark Meadows, and Mike Roman. Mike Roman was represented by Merchant, who came here and testified. In Wisconsin, they also indicted Cheeseborough and Roman. And so, we could go on and on about in the federal case had only one defendant, Donald Trump, but he was also indicted in my case. So these defendants committed crimes in our state and other states, and there's all this talk about political enemies. Not one of these defendants do I consider to be my political enemy. I'm sorry that they think of me as an enemy. I guess they don't know that their job is to serve me, to work for me, to make life better for me and my family. But they are not my political enemy. And I actually pray for them because I see issues.
And also within Wisconsin, the quote unquote fake electors there actually got sued. And the discovery in that case was over 577 pages. Now, you didn't get to the discovery process in your particular case, but I'm just curious because we were talking about Mr. Scandalakis and his maybe how deep he got into your case. How voluminous was your case at the time it stopped?
Huge, much of this room it could fill up, if not all of this room. It was huge. It was lots of witnesses that had to do a lot of work was put into this, because I always want to make sure that I am a fair DA, and that's why you see a grand jury recommending 39 people based on their conduct being indicted, and me cutting it down to 19, because I'm only going to put forth those with the worst evidence, who did the worst things. But I'm also a fighter for victims, and I was fighting for the victims in this case. And the fact that, to some prosecutors, Ruby Freeman and her daughter have no value. She has value to me, and she should have value to other Americans, because what happened to her is horrible. And for someone to say they couldn't prosecute a defendant who came in a room and lied for the grand jury, I mean, a baby prosecutor could have prosecuted it, but, that's neither here nor there.
And lastly, where we're talking about billing being correct or things of that nature, or critical mentions, does any of that change the impact? I think what these co-conspirators were doing, based on the indictment, that the ultimate goal was to overthrow the 2020 election.
That was the ultimate goal. And we've had people that are supposed to be leaders that, instead of being leaders, are just cowering down. This country needs leaders, not cowards.
I don't have anything else, Mr. Chair.
Thank you, Leader Jones. I've got a few more questions here. Some of this, Madam DA, will be a little bit more, philosophical manner. I want to get your take on some of the testimony that we've had prior to your arrival around some of the state laws. You've shared some of your thoughts already on some of those things. But one thing that we've talked a lot about in the committee is the use of special purpose grand juries. Can you, for the benefit of those watching, outline the difference between a grand jury and a special purpose grand jury?
Special purpose grand jury is for the purpose of investigating. They are not legally allowed to put forth an indictment. And so that is what a special purpose grand jury is for.
So, and you referenced this earlier, the process of going to two grand juries. In your case, with the use of the special purpose grand jury, you went from that special purpose, which was used for investigatory means that you mentioned, and ended up ultimately with a grand jury. Is that correct?
That is correct.
Okay. It's been described to me that a grand jury exists to essentially put a check on prosecutorial power, to require the prosecutor to have to prove some element of grounds to bring an indictment. Would you agree with that statement?
It's one way to phrase it.
How would you phrase it?
That a grand jury is made up of citizens, that the citizens are brought there. I'm the only DA in the state. I do grand jury 4 days a week. So I have a grand jury. It runs on Monday and Tuesday. And I have a B grand jury. It runs on Thursday and Friday. And we bring forth cases to the grand jury. We're usually law enforcement, but sometimes lay witnesses testify. If the grand jury finds that there is adequate evidence, they will put forth an indictment. It should be known by the general public that not all felonies require an indictment. Some of your lower level felonies you can do by accusation, just like you could do a misdemeanor. But for any serious felony, you need to go to the grand jury.
You may have touched on this, and I'm just going to ask you to, in the context of this conversation, outline it again if you don't mind. What was the reason for the use of a special purpose grand jury in this election case?
To investigate, to make sure. I took this matter very seriously. I was not just going to charge people with a crime before I found evidence. And sadly, a lot of people in government, the governor, and other officials, refuse to testify unless they had a subpoena. Well, I can't get a subpoena unless I have a special purpose grand jury. And so we served them with subpoenas, and they honored their subpoenas, and they came forward.
So with the grand jury for out-of-state witnesses, there's no way to get, for a regular grand jury, to get a subpoena?
For a regular grand jury, but by the time you're before a regular grand jury, you're indicting. And I didn't go into this case knowing that there would even be an indictment brought forth.
Tell me about a material witness warrant, what the process is to get one, and when one would be used.
When someone won't cooperate, you have to go get one.
Do you have to get one for all out-of-state witnesses unless you're using a grand jury? I'm sorry, a special purpose grand jury?
You can get a material witness warrant for a witness in a trial. We have had to get material witness warrants for someone in a trial. So I don't know that I understand your question, but basically when someone will not cooperate, it requires you to go get a warrant. Typically, you have to send someone to that state. They have to testify as to why this person is material. Then the judge there makes a determination. Yes, they are material. They sign the warrant. They come down. That's very brief, but that gives you kind of the gist of what a material witness warrant has been used. I've used them many times in my career.
My understanding is essentially you need two judges. What sounds like one's the out-of-state judge, one would be a Georgia judge to compel that testimony. Is that accurate? Because
they have to make a determination that it's actually material.
And with a special purpose grand jury, you have the ability to send essentially a letter and a warrant to whomever you wish and compel them to testify without the process of going through the material witness warrant. Is that accurate?
Yeah, again, we're getting into the weeds. We needed a special purpose grand jury because I need to be able to issue subpoenas. So you can issue subpoenas from the grand jury to bring the people there to testify. And so if you're asking that we do that process, we fought in every court in this land. Lindsey Graham took us all the way to the Supreme Court of the United States, who unanimously, I believe, I think it was unanimously voted that he would have to come in to appear.
We are getting in the weeds, and just indulge us because we do need to. The law needs to be specific, and not sure if you watched the testimony. We had a couple of DAs that testified, one of whom, and I apologize, I don't recall the gentleman's name. He essentially, I'm going to paraphrase here, said that he believed that, or I think he stated that it would be fine with him if we struck the entire code section as it related to special purpose grand juries, because in his opinion, that kind of blurred the line between investigator and prosecutor and put you in the position of kind of being the investigator and the trier of fact. I don't know if you've heard about this testimony or not.
I haven't heard this testimony, but what I do know is Coca-Cola and the girl that sells lemonade, they both sell liquids, but it ain't the same work. And so you brought people from jurisdictions that do not do the complexity of cases that I do. Now, all work is honorable work, so hear that. And prosecutors everywhere are trying their best to uphold the law. But to get somebody from a jurisdiction where they got 15 lawyers and, they bring a grand jury once every 6 months, and to ask them to discuss my work where I'm running grand jury 4 times a year and 12,000 new felony cases. I'm sorry, 4 times a week, and 12,000 felonies a year is the most complex cases that this state sees. I don't think you were talking to people that you should have been. So I disagree with him, and I don't even think he has the ability to comment on the work of the Fulton County DA.
Well, in fact,
and I noticed that you didn't bring any diversity here when you brought witnesses. You brought all Republican, Caucasian people to come and to tell you about my work. I don't need daddy to tell me how to do my work. I know how to do my work.
Yeah, I don't recall any of the DAs that came commenting on your case at all or your work at all. It was more so trying to get a broad swath of the state, somewhere from.
But it would be like me telling you how to run a DA's office in a rural community. I don't know.
Well, the challenge for us, Madam DA, is we have to write laws that do give respect and deference to the reality that there are larger jurisdictions like yours, and there are smaller ones, and there are a lot of DAs around the state that have to follow the same.
Well, that brings us to another law. When you all are trying to decide the salaries of district attorneys, you surely should not compare those that have my volume of work to those that have smaller jurisdictions of work. Now, I know it brings ire to some, that is the Democratic DAs that keep most of this state safe, but the reality is they run the largest jurisdictions. They happen to, in most cases, be minority, and they deserve to make more money.
Mr. Chairman, may I know that I'm just advised, but since I was here when we did investigative grand juries and all, could I explain the difference?
Governor, I think we'll defer to you, not because you were a governor, but because you started your illustrious career in the Georgia State Senate.
Well, I started as an assistant DA.
Well, your first elected role was in this chamber.
When a grand jury, and there are lawyers everywhere that do not understand this. when a grand jury, you present a bill of indictment or special presentment, you can do it either way, to a grand jury, then there has to be laid before the grand jury a specific bill of indictment alleging facts, circumstances, and the defendants. And you just can't use a regular grand jury to say, well, we need to investigate this. The law goes back to the common law. It has to be an indictment, perfect in form, laid before the grand jury, charging a specific person with a specific crime. So there is no way for a regular grand jury to investigate, unless they are given some civil investigation powers, for example, the jail, things like that. But in a criminal case, the case has to be made on that bill of indictment. So in a investigative grand jury, and they're rarely used, but investigative grand jury says something went wrong here. And I don't know exactly who should be indicted, and I don't know exactly what they should be indicted for, but it deserves investigation. And where a grand jury may be drawn and is set in statute, an investigative grand jury requires the additional step, so that it won't be misused, that the additional step that, in fact, it must be approved by not only the district attorney, but the chief judge. Not that I'm trying to instruct you on the law, but.
Remind me, Madam DA, how many times in your career as a DA of Fulton County have you employed a special purpose grand jury?
Once.
Okay. Chairman Calzert, who obviously I've said before can't be here today, he has contemplated this concept of a statewide grand jury. And one of the things that he and I talked about was just getting your thoughts on whether it's appropriate for the Fulton County DA and Fulton County grand jurors to have sole authority and responsibility, essentially for prosecuting all state level officials, simply because the capital is here in Atlanta, or what your thoughts might be on with that resting with the Attorney General and a local municipality. In this case, that would be, or a local jurisdiction, which would be your office.
And that's the real issue. And I know that it bothers you all that the district attorney in Fulton County is me, but I think you absolutely need, when laws are broken in someone's jurisdiction, they should have the ability to prosecute them. There is no need to do that in that way. And the reality is, I prosecute more cases than the Attorney General. We are equipped to do it. We are doing it. I think that what has happened is the complexion of the DAs have changed. And so now there's all this concern. Now we need a QAnon committee, the oversight committee y'all have come up with. Now we need a statewide grand jury, and we need to take rights away. No, it's just fine how it's always been.
I think what he's contemplating, at least as he kind of jotted some thoughts out to me, would be concurrent jurisdiction, where you would still have autonomy, but the Attorney General would also have the ability to prosecute cases. You would be opposed to.
They already have that ability.
Okay.
They have that ability. So then they have the ability.
That may be the distinction that he was getting to. I just want to get on the record because he couldn't be here today, and that is something that he asked about. We heard from, and I'm just going to summarize this because I know we are getting short on time. I do want to talk about federal grants because it was discussed in this committee.
Did you hear me say I just passed another audit?
I did hear you say that, I believe. That asked and answered, I believe, as y'all would say. I don't think you gave us this number, but what's a ballpark number of federal grants in an average year of what y'all receive? Is it hundreds of thousands? Is it a couple $1 million? Is it?
I don't know an exact answer. I can tell you we do excellent work with our grants, and because of the current administration, not just in my office, but all over the country, people are losing valuable grant money to do the work of the people. And that is going to require some work of the legislature because the state's going to have to kick in more. This year alone, I lost 14 employees as of September 30th because not as many grants are being given. Grant work that just does excellent things for community. And the grants, so that we're clear, they're actually not the Fulton County District Attorney's grants. They're not the Atlanta Judicial Circuit's grants. They are the grants of the county. So they are not my grants. So that's a misnomer slang.
Of those 13, were they prosecutors or were they admin? What do they do?
A combination of everything. Some lawyers, some investigators, some staff.
Okay. I want to
And those weren't all federal grants.
move quickly through, and I don't want to belabor this, but there was a letter that I want to ask you about that came from Senator Grassley relative to grants. And then we heard testimony from someone who I believe used to work in your office, is no longer employed, named Amanda Timpson.
Yeah, all of her, about 5 of her cases have been dismissed now. So I think that you should know that on summary judgment, because she gave this committee information that was incorrect, and her cases have been dismissed. You're not soothsayers. You wouldn't know that as you went into the future, but facts were provided to you that were inaccurate, not true, and those cases were dismissed. And it's about 5 cases, some dismissed by her counsel. One was just dismissed on summary judgment. I've not misused grant funds. You were given false information.
Let's
That's not the only witness that gave you false information, but that one certainly did.
Okay. And I'm going to kind of cross-reference a couple of things that was the testimony from Ms. Timpson. I also reference a couple of things in the letter. The letter specifically notes that your office received $500,000 in 2020 to open a youth empowerment and gang prevention center.
You know, I wasn't the DA in 2020.
Correct. I'm just going to ask you if the money for the grant has been used for that purpose, to your knowledge.
I wasn't the DA in 2020. I can't speculate.
After receiving Mr. Grassley's letter, did you have the opportunity to look into the use of that
I don't
$500,000?
believe I did. I don't think I responded to Mr. Grassley.
Okay. The letter highlights a report that roughly $89,000 of those funds have been diverted to what is known as the Offender Alumni Association. Is that report accurate to your knowledge?
I don't have any knowledge, and I'm not going to speculate.
Okay. When Ms. Timpson was here, she previously testified that she discovered the office was using these grants and expenses that were not eligible for the grant. Specifically, she mentioned swag, computers, and travel.
And didn't know what she was talking about, which is why her cases were dismissed.
So is it your testimony that the funds were not used for swag, travel, or computers?
Let me speak specifically to the one that I know about.
Okay.
I bought a computer for a grant employee. I did not use grant funds to buy it. I can, which I do with all my grants. It's never enough. So you always do things to support the people working on the grants. But what I can tell you is her cases were dismissed because they had no merit. One was just dismissed on summary judgment.
She testified that she had brought this to your attention in late 2021. Do you recall that conversation?
I do not recall it. What I recall is Ms. Timpson being a troubled employee that did not do well at the office, that I moved her. I remember she was one of those people I interviewed. I remember feeling terribly sorry for her because she's got a tragic story. So I was proud of that she had kind of lifted herself up by her bootstraps, but she ended up being an employee that was a holdover employee and not very good at her job. We tried to work with her. Ultimately, she put some of my employees in fear, and she was let go. And that's what I recall.
And she was let go in January 2022.
I don't remember. I've had up to 400 employees before the ARPA money was employed. I literally have no idea. She obviously was not a lawyer or an investigator, and that is the tiers of my office, a lower level employee. I don't remember.
Okay. Going back to Grassley's letter,
I told you I didn't respond to Grassley's letter. I don't remember it. It doesn't stand out to me. It wasn't important to me.
I'll just highlight for you one thing he said, just allow you to clarify if it's accurate or not. He cites a report in the letter that says that in 2023, 98% of these federal grant funds were spent on travel and conferences.
I don't know if that's true or not. I doubt it's true. But if it was spent on travel and conferences, it would have been allowances of the grant. But that sounds inaccurate to me. But again, we're speculating.
Okay. Chairman Grassley asked you for a series of documents, and based on what you just said, I think I know the answer to this question, but I just want to clarify. He asked for a list of all federal grants received by the office since 2019, complete accounting of all expenditures of grant funds, reports related to planned expenditures of those funds. Have you complied with Mr. Grassley's request?
I believe Mr. Grassley was ignored.
Okay. Would you be willing to provide those documents to this committee?
I think you've been provided documents. What did happen was I provided documents to Jim Jordan.
Do you know if federal grant uses and sources and details that was requested by Mr. Grassley would have been captured in what you provided to Mr. Jordan?
Have no idea. This is a large office. It's not a rural office. I have a grant team.
So if we request these documents, you'd be willing to provide them to the committee?
Whatever's been provided is what I was willing to provide.
Okay.
We'll consider. But I think it is included because I went to Washington on the Jim Jordan committee.
Can you say that one more time?
I went to Washington on the Jim Jordan committee twice. And not only did they have all the documents, they sent another team of auditors down and they said everything was still correct.
I just passed a federal DOJ audit this week.
The Fulton County Ethics Code was amended in April of 24 to clarify that it includes elected officials. Is that your understanding?
I have no idea what Fulton County did.
That wouldn't apply to her.
Yeah, I'm not a county elected official. I'm a state.
She's a state elected.
Right.
Not a county.
Okay, so your position would be that the county ethics code, anti-nepotism code that they updated to include elected officials, when they expanded that scope, that would not include you. That would be
There's county electeds and there's a state elected. I am a state elected.
Okay.
I represent the Atlanta Judicial Circuit.
Does PAC have any sort of model language around either internal ethics codes for your office to use or any sort of anti-nepotism
You have to ask PAC.
language? Are you aware of
I'm not.
anything that PAC has provided? Can you provide the committee with any sort of internal ethics guidelines that you have, as well as any sort of anti-nepotism policy that your office has in writing?
You know, that's subpoena them. We'll consider and decide whether it's relevant to the inquiry or whether it's privileged or whether you've already received.
Okay. Does an internal ethics policy exist in writing?
You know, you mentioned companies, and you know, it's interesting because I also saw where you posted where it's always Fulton County. But the truth is, you have a company that you've listed on your disclosures for finances, and that company stole millions of dollars from Fulton. If you want to look at ethics, you might want to look at that.
Does your office have
And
any sort
the
of
company's name is
internal
Teletrax, in case
ethics?
anyone thinks I'm making this up. And people died because that company did not provide the services that they purported to provide.
Does your office have an internal ethics policy that's in writing?
Not that I can recall.
Okay. I want to lastly just ask a couple of questions about the Open Records Act.
Let me tell you something. I have a 92% conviction rate and a 92% clearance rate with open records from January of 24 till November 30th of 2025. I've gotten over 1,600 open records requests. This ain't a rural town.
Say that number again. I'm sorry.
Over 1,600. And we have cleared 92%. Now, it should be noted that in 24, people were abusing the open records thing. Ms. Merchant, as you mentioned, over 30 requests for open records. Lots of people were abusing it. And it troubles me that in 25, I have to now start charging people for open records because I realize people will abuse it. But 92% of the open records requested, we have cleared.
Can you define cleared? What do you mean when we say cleared?
They've asked for documents and we've given them to them.
Okay. And you mentioned you're now having to charge an hourly rate. There were no hourly rates. that
Not
were
from
being charged.
January 1st of 2021. That was a novel idea. A young, naive, new district attorney did. I thought that I could provide documents, or I wanted to have transparency. I wanted to be able to communicate with the public, and I wanted indigent people as well as rich people to be able, if they had something, to give it to them. What I didn't know is that there were a lot of evil people that would abuse that to make up lies.
Can you clarify for me? You said you started charging just earlier this year.
January of 2025.
Okay.
But I don't take in those funds. I had Ms. Whitmore do that.
Prior to your getting sworn in, did your office charge for open records requests?
I believe the prior DA did charge for open records, but you know, when you become the new DA, you have new ideas. One of my new ideas was I wanted to offer this level of transparency to my constituents. It was
Okay.
abused by people all over the country.
you referenced certain individuals abusing the process.
Absolutely.
When you said 30, just to take the example of Ms. Merchant, just since she has been before the committee, you said she filed 30 open records requests. In what
More
period?
than 30. It was 30 it was a little bit in excess of 30. Yes, I did say that.
Over what period of time?
I don't remember. I don't remember.
Generally speaking, in kind of the scope of the
I don't remember, so I'm
case of
not
the
going to
elect-
speculate.
Okay. What, in your opinion, what
I know
should
she also came in here and testified that I diverted money from my homicide backlog. I cleared my homicide backlog, all of it. Didn't divert any money. People came in here and lied to you. You should be upset about that.
in the as you think through the law, the open records law currently is unlimited, right? Somebody can
I think if you
Can-
want a new open records law, you should make the legislature have to answer open records. That would be my recommendation for a new law.
I would vote for that as well, but let me just get I just want to get your opinion on the scope and how you would limit that, how you determine abuse versus non-abuse.
How I would limit open records? Is that what you're asking me?
Yeah, if you were to take an extreme case, right? If you say 30, I think
I don't think that district attorneys should actually be subject to the open records, but if they are subject to the open records, obviously attorney work product should not be subject to it. Only cases that are, completely closed, and I mean closed past the habeas, you should have to give.
help me understand why you don't think you should be subject to open records. I would agree with you that the General Assembly should be.
Judges are not subject to open records.
Do you think they should be?
Did I think judges should be subject to it? Not their work product, because judges also have work product. But I think they should be akin to DAs.
And do you think DA should be akin to the legislature? Or you think that the legislature should be akin to a county commissioner?
I don't know that I understand your question, but I think that you should be subject to open records. I think that you're making laws that are supposed to be in the benefit of the community, as opposed to this day where we're wasting a lot of time, where me and my staff could be keeping the community safe, but I'm here to do this song and dance with you. The reality is I brought forth an indictment because people came in my county, they committed a crime, and they got charged. They didn't get charged because of their race. They didn't get charged because of their political party. They got charged because they came in my community and committed a crime, and 2 grand juries passed forth an indictment. And this is what you should know. I don't care how many times they threaten me. I don't care that they've threatened my family. Actually, just yesterday, I went home and the Department of Justice sent me a letter about another person that they are prosecuting, and that I can come in January because this person swatted my home as well as the home of other public officials. This has to stop. What you all need to do is to pass laws to allow people to do their jobs, to do them safely. What happened to Marjorie Taylor Greene is horrible. That she had to quit her job because they were bomb threats to her house and threatening her children, but she didn't care when it was me. She didn't care when my children were threatened. She didn't care that I haven't had the ability to live in my house, but I'm a better human being than that. I don't want any of your lives threatened. I may not care for you personally. I may not believe in your politics. I may think that today is nothing but more than evil and you trying to get yourself elected. All of that being said, I don't think anyone should threaten you and your family. And I think if you're here to protect, you ought to establish laws that if someone uses hate speech and that creates an environment where people like myself are threatened doing their job, we ought to do something about it in Georgia.
Just a couple of quick questions on the open records law and your thoughts on it. And it doesn't, and I think it is a challenge to get to this concept of what is abuse and what is not abuse. As it relates to Ms. Merchant, though, the court seemed to indicate that
The court indicated that a CFO would not be in the weeds, as I was not. And we gave Ms. Merchant many, many documents, and she abused it. So if you look at what they said, the court said that the CFO, which is what I am of the district attorney's office, I wouldn't be involved in the weeds. What I know is that when you have 1,600 people requesting, we do the very best we can. What's a shame is because we had people abusive, I now have 3 attorneys working on open records, 2 master level peoples, and an employees. None of those people are doing the work that I care about. What I care about is getting gangsters off my street. What I care about is getting people that sexually assault children. I don't hang out with human traffickers or the victims. I care about representing people that are trafficked. Like, we've got problems here in Georgia. They're real problems. This is a major metropolitan city, and I'm standing on the line here trying to keep people safe, and y'all have me in here with this foolishness. I indicted them. I'm indicting them again if they committed a crime in my jurisdiction. I don't care if you like it. It's not
Let me get to
1948.
the-
No, let me get to this.
I didn't
It's
get to the
not
question.
1948. I know that you're
Madam
offended
DA,
that it.
I didn't. So here's the question.
Audacity to indict rich white men, but I would do it again. But I would also fight with my last breath to see that they were protected.
What I was asking was, and I didn't get there. The court essentially found that Miss Merchant was treated differently than other people making open records requests. You're correct. It did find that you were not in the weeds on dealing with that. What I'm curious about in response to the court case, have there been any internal changes with how you handle?
I now have
Other-
3 lawyers on open records,
other than-
2 master level people, and an assistant. That was the change.
Okay, so
I had to waste more resources to not do the main thing. So you want something else? Give the district attorney in Fulton County more lawyers so that she can do our job. Because what happens in Fulton is going to impact the entire community. Gangbangers don't stay just in Fulton. They go to DeKalb, they go to Coweta, they go to Douglas. And I'm here on the front line keeping people safe. And you talk about critical
So
mention.
just walk me
It
through that
wasn't
change.
just about this case. I prosecute a lot of high profile cases.
Walk me through the change real quick. What did you have before in terms of staff, and what do you have today?
When I started, I had one.
Well, when I say before, let me say, let's call it 2024 versus 2025.
I've increased staff. I now have 2 special assistant attorney generals that work on it. I have two special assistant prosecutors that work part-time on it. I have right now 2 lawyers that work on it full-time. I'm bringing a 3rd one in. I have 2 master level people that work on it. When I first got there was one lady with a master's degree. We've had to expand and expand and expand for this foolishness. And what I'm supposed to be doing, and my main emphasis, what I focus my day-to-day on, is making sure I lock up murderers, making sure I lock up sexual offenders, making sure I lock folks up that are dangerous. And I also spend my time on making sure we have programs for people so we can turn their lives around. Which is why I got a 92% conviction rate. I must be doing something right.
Leader Jones, I've asked a couple of questions since you've had the opportunity to ask. I want to defer to see if you had any questions you'd like to ask before we wrap up here. Let me turn your mic on.
One final one, you kind of touched on it, and that was, at the end of the day, this case here, this conspiracy case that took place, why did you bring this case?
Because folks came in my jurisdiction and broke the law. And as elected officials, there are things that are precious and that are our responsibility. One, in a free society, is keeping people safe, right? And I stand on the line keeping people safe every single day. I have dedicated my entire career to making sure that people are safe and that they feel valued. Children feel valued, no matter who you are. See, I'm not like these people. I believe in diversity. I've sat on my floor and cried with little white children, Black children, Spanish children, and I fight with my last breath to keep those people safe. But I have also prosecuted Black people, white people, Asian people. It doesn't matter to me. It seems to matter to some. So I brought this case because they came in this jurisdiction and broke the law. And they didn't only break the law here, they broke it other places. Because the other thing that we have to do as a free society is we have to protect elections. It is important. If the people of this jurisdiction, the 19th, voted Senator Blake Tillery to be that senator, then I have to work to make sure that he is instilled into office. If someone does something, goes into a voting booth like they did in Coffee County, they do that. If they threaten workers, these little old people that work the polls, how dare somebody threaten them? And how dare you all not take that to be important? Is it not important because it was an older Black female? It ought to be important to everybody. That's who you all are here to protect, those that cannot protect themselves. And I'm willing to stand on the line so y'all can keep threatening me, keep bringing me to these committees, keep auditing me, and I'm going to keep doing my job with excellence.
All right. No other questions.
Madam DA, would like to thank you for appearing today before the committee. Governor Barnes would like to do the same.
Good luck and God bless you all.
This meeting is
Happy holidays.
Hello, everybody. Welcome to the 9th video in my Antonio Sledge series. This is going to be the culmination of several of the prior videos, most specifically the most recent one in which I show that the state was relying upon the wrong version of Antonio's plea agreement. It presented the wrong plea agreement to the court. And you can probably watch this one without having seen that video, but you'll definitely have more color for this video if you watch that one first. But yes, this is the day. This video is going to review the day on which the state showed a video of parts of Antonio Sledge's guilty plea hearing. And what I'm going to explain to you is how deeply misleading their edits and manipulations of the video were. And I'm also going to prove that Max Sharp is a genius along the way. So here we go. This first clip's going to be the morning of day 124. The state is going to explain that it's created this morning, by the way, the morning of 124. They created and sent an edited video of Antonio Sledge's guilty plea hearing from December of 2022. And the hearing is September of 2024. So it's almost 2 years later.
Your Honor, the state has now sent to counsel for the defendants and to the court, I believe you just, the edited version so that there's no starting, stopping, or muting. It has the portions we referenced that we intended to tender as either a prior inconsistent statement, contradiction. It has what we referenced.
Okay, well, I wasn't able to access it because I don't have the permissions, but I mean, I can tell what
Did you say?
parts, I think. Is there an objection to that?
So, Your Honor, we have not reviewed the edited version. So, because we
All right, well, I'm going to assume that what Ms. Love says is in there and out is what's in there and what's out. So let's just take her at her word as an officer of the court.
Okay.
And
we, as I understand it, the state's attempting to introduce this as prior.
No comment. I'm going to skip ahead to another issue. Let me see here.
Okay. Is the edited version, has the law and crime been taken out? Okay.
so this is just essentially going to be him swearing to tell the truth, identifying himself, and then it's going to be the factual acknowledgments that he says, no, these aren't true. And then the sentencing understandings or whatever that he says, I didn't understand any of that at the time. And then the bottom, that's where he says, I have read and carefully considered all of this, and I've made any changes I want to, and this is all true.
What it has is, in addition to that, so it has the very beginning where he raises his hand and swears.
We don't need to listen to this part. That's basically, Judge Whitaker just basically explained what the video is supposed to be. It's supposed to be a complete portrayal of the guilty plea hearing, where Antonio, swears to various things being true. There are a million issues with that, but we've explored those in past videos. Basically, the video is just supposed to be a complete but slightly redacted portrayal of that 2022 hearing. So we're going to skip ahead now. 254. Let me see here. And we are going to take a look at the beginning of the video.
All right, we're on the record in the matter of the state of Georgia versus Antonio Sledge in 22 SC 183572. Good afternoon, Mr. Wright.
Good afternoon, Judge.
Good afternoon, Mr. Sledge. Good afternoon, Your Honor. And good afternoon, counsels Love and Hilton.
Love and Hilton. I just want to show that part. These same two attorneys that were at this hearing in 2022, that's on the screen now, were also present in the courtroom in 2024 when they're showing the, edited version of this video. So they were there. They know exactly what happened at that hearing. So this isn't a case of, mistakenly, misunderstanding or misconstruing what happened. They were there for the whole thing. Let's see. You can jump ahead to Max being a genius. Here we go.
States 1AS is count 1, 15 years on probation, and count 30, sentencing withheld until years on probation, and count 30, sentencing withheld until years on probation, and count 30, sentencing withheld until years on probation, and count 30, sentencing. We might need to skip forward to.
We might need to skip forward 2 seconds. Surely those 2 seconds aren't the two most critical seconds in the entire video. Surely.
Try that.
I'll also note the time there at 6:40.
The agreement is not captured. I'm going to object to skipping forward. I'll see.
Let's see.
Max is completely correct. As you'll see in a second. But listen to what his specific objection was.
Is not captured. I'm going to object to skipping forward.
One more time.
The agreement is not captured. I'm going to object to skipping forward.
The agreement is not captured. I'm going to object to skipping forward. I wonder if he's right.
I'll see.
Let's see.
Your Honor.
I'm not saying to skip anything substantially. I'm trying to
Right.
see if they can skip over the part where it's just repeating
Skipping,
itself.
yes.
I'm not saying to skip anything of substance. I'm just saying skip the part where it's repeating. I wonder if they skipped anything of substance, as I just kind of told you a second ago. They did. Let's jump ahead to where they pick up. Here we go. This part maybe?
We're sharing through a different screen, and we're going to go ahead and pick on these charges at 6:40 where we stopped.
Going to pick up at 6:40 where we left off. That's what they said. Did they pick up at 6:40 or did they pick up at 6:42?
It has complied with the special conditions outlined in section B as in boy. C.
Let me explain to you how important those 2 seconds are. Make sure I have the right part queued up. Here we go. This is the transcript of the hearing. This is the part that they were just showing in the video. What was being shown was, I believe this was Love speaking. She says, the negotiated sentence is outlined in states 1AS is count 1, 15 years on probation, and count 30, sentencing withheld until. That's all you hear. Well, I mean, it says that like 6 times because it was repeating. They skipped the 2 seconds that are underlined. Until the completion of the initial trial of this case, after the initial trial of this case, and then you hear, I believe it picks back up, provided defendant has complied with blah, blah, blah. So what they're skipping is until the completion of the initial trial of this case. It is the most important sentence in the entire hearing by far, because from that one sentence, you can look at the disposition that, let me rephrase that. From that, the underlined phrase, if you were to hear it and then look at the sentence that was imposed on Mr. Sledge, you can tell that the plea agreement that is being presented to the court is not the correct plea agreement. Let me explain to you how that is. This is the plea agreement that the court in the state was saying was the correct plea agreement. You can see that right here. Count 30, sentencing withheld until the completion of the initial trial of this case. And again, that's what's read here. They skipped completion of the initial trial of this case when they showed the video. If you look at the sentence, you'll see that sentencing was not withheld until the completion of the initial trial of the case. The sentence was actually imposed on count 30. So again, this is the sentence this is the plea agreement. Because the sentence has a sentence on count 30, this final disposition reflects a sentence on count 30, you know that this cannot be the correct plea agreement because this says you're not going to have a sentence on count 30. So just the existence of this sentence shows that you have the wrong plea agreement. And what did the video, what did the state omit from the video? Until the completion of the initial trial of this case. So it says negotiated sentence as outlined in 1AS, count 1, 15 years on probation, and count 30, sentencing withheld until. They don't actually show the part that says until the completion of the initial trial of this case. If they'd played that clip and any of the defense lawyers had looked at the sentence that had been imposed on Antonio, that would be a major red flag. And because the video just happened to skip and miss those 2 seconds, as Max said very correctly, they did not show the entire agreement because those 2 incredibly critical seconds were skipped. Max was completely correct. Completely correct. And for the exact reason that he said. Now, I don't know if he knows that, but I'm going to give him credit for it anyway.
Big developments in the case of Dwayne Keefe D. Davis, the man accused of orchestrating the murder of rap icon Tupac Shakur back in the 1990s. All these years later, the former gang leader is behind bars in Las Vegas and is insisting the case be thrown out. And he is implicating another music legend who's making headlines, Sean Diddy Combs. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber. Dwayne Keefe D. Davis is said to be behind one of the most infamous killings in history. Tupac Shakur, the 90s rap superstar, was gunned down while riding in a car with Suge Knight after the Mike Tyson fight at the MGM Grand. And over the years, there have been multiple investigations into Tupac Shakur's murder, but there has been one man who has seemed to implicate himself in the assassination again and again and again. Dwayne Davis, also known as Keefe D. By the way, spelled sometimes with 2 F's, sometimes with 2 E's, even sometimes with a Y. Gets a little bit confusing, but Keefe D. Now, Davis was reportedly the leader of a sect of the Crips street gang in Compton, California that dealt in drug sales and trafficking. Davis eventually did time in prison on drug charges in the late 90s, but since getting out, he has been more open about his apparent involvement in Shakur's death. Davis released his own tell-all book. It's called Compton Street Legend, Notorious Keefe D's street-level accounts of Tupac and Biggie murders, death row origins, Suge Knight, Puffy Combs, and crooked cops. And he started granting interviews with YouTubers who wanted the inside scoop on what happened on that night back in 1996 out in Las Vegas. So Davis and several members of his entourage apparently attended the Mike Tyson boxing fight. But afterward, in the casino, Shakur had attacked Davis's nephew, Orlando Anderson. The fight had apparently been sparked by a previous beef over an alleged stolen neck chain. So the men eventually separated, the 2 groups went on their way, but Anderson, Davis, and others that were with them were reportedly still pretty heated over what had just happened. And later that night, allegedly, their plan was to target Shakur and Knight. And Knight, of course, is the head of, or was the head of Death Row Records, as they were all stopped at a traffic light. This is what happened. Now, in an interview with the Art of Dialogue channel, Davis said he was in the front passenger seat that night with DeAndre Big Dre Smith and Anderson in the back seat of the rented Cadillac. And what happens next? Who fired the shots? Take a listen.
Dre, he was the one that was supposed to shoot, Tupac and Suge, but he got scared, right?
No, he didn't really get scared. He wasn't ready for that. They was youngsters, man. Kids.
But once again, y'all Crips, right? So he should be used to that, right, Dre? So why was
he wasn't ready for that? Everybody got a role, man. Everybody ain't killers. Everybody, you know what I'm saying? Everybody ain't gonna kill.
So
everybody
Dre,
ain't
he
with
wasn't
that.
a shooter?
No.
Okay, so but he was the one that was supposed to shoot up Tupac and Suge, but for some reason he wasn't ready for it, so he gave the gun to Orlando, right?
Something like that, yeah.
And Orlando is the shooter. He's the known shooter. Everybody know Orlando Anderson was a shooter. So Dre got cold feet. He didn't want to do it. He gave the gun to Orlando, and Orlando shot Tupac and Suge.
Yeah, he did his thing. Yeah.
Now, let's be clear about something. Anderson has always denied that he was the killer. In fact, he died just a few years after Shakur in another shooting. The other men in the Cadillac, DeAndre Smith and the driver, Terry Brown, they are also both dead. But Davis told a lot of this information to Los Angeles and Las Vegas investigators as well. And this is after he apparently became a confidential informant for a task force that was looking into the murder of Christopher Wallace, also known as Biggie Smalls and the notorious B.I.G. By the way, we're about to talk about Diddy. We did a whole separate sidebar episode on how Sean Combs' former bodyguard came out recently, spoke on a documentary, and saying that Sean Combs could have been involved in the murder of Christopher Wallace. I encourage everybody to check it out if you're interested. But then going back to Tupac, we go to September of 2023. So this is 27 years after Shakur's death. And Davis was arrested near his home outside of Las Vegas and taken into custody. And since then, after he's been charged with the murder of Tupac Shakur, he and his legal team have been working to get him out of jail and to get his case thrown out. Now, we can say definitively he has lost both of those battles. He has pleaded not guilty to first-degree murder. He's supposed to go to trial in March, but I want to explain a little bit more about this. So earlier this month, Davis's defense team filed a motion to dismiss the case. And as part of his argument, he is pointing the finger, seemingly, at Sean Diddy Combs as the one who really is responsible for Shakur's death. Yeah, this is one of those stories that we've been constantly trying to keep an eye out for, bring you updates as they develop. And for that, I got to call out our amazing sponsor, Morgan & Morgan, because their support helps us to keep on doing this. But here's the deal. If you're injured, Morgan & Morgan, the exclusive personal injury law firm of law and crime, America's largest injury law firm, that may be who you want in your corner. You know why they have over 1,000 attorneys? Because they win a lot. In the past few months, Morgan & Morgan secured a $29 million verdict for a bicyclist in Philadelphia, a $2.7 million verdict for a car accident victim in Florida, and not to mention $5.6 million for a car crash victim in Georgia after insurance offered that client $0. And even if you think your case isn't worth millions of dollars, why not start a claim and fight for what you deserve? Morgan & Morgan, they make it so simple because you can start a claim from your phone in just 8 clicks. So if you're injured, you can easily start a claim at forthepeople.com/LC sidebar. Now, at the time of Shakur's death, Combs was beginning his meteoric rise to the top of the rap world. He had started Bad Boy Records, now called Bad Boy Entertainment. And of course, there was this ongoing feud, West Coast versus East Coast, with this feud that he had with Tupac Shakur and Suge Knight, again, the leader of Death Row. So I want to take a look at the legal arguments that Davis's team had in their filing. And it reads, Defendant Dwayne Keith Davis hereby files this motion to dismiss on the basis that the state of Nevada has failed to timely pursue these charges against Mr. Davis, failed to provide corroborating evidence to support Mr. Davis's coerced confession, and failed to honor the federal proffer agreement between Mr. Davis and the United States government, thus substantially impairing Mr. Davis's constitutional rights. So 2 big arguments here. One is that the government waited too long to file the murder case, 27 years. They claim that this was done maliciously. By the way, though, typically speaking, there are no statute of limitations for murder. But even if they had filed the charges sooner, this is Davis's other argument, Davis says he's immune from prosecution thanks to an agreement he had with investigators when he was hauled in to talk about Tupac Shakur's shooting. And listen, remember, Bill Cosby, we all remember what happened to him. His conviction for drugging and raping a woman was vacated because his due process rights were violated, since a former DA had, in fact, made an oral promise to Cosby that he wouldn't be prosecuted. And remember, Cosby relied on that promise to admit some incriminating things about that encounter. So a high court actually determined his conviction should be thrown out. But going back to this, the first big interview that was referenced in the filing is from a couple of years after Tupac Shakur died. On July 16th, 1998, Mr. Davis was interviewed by Assistant United States Attorney Michael Terrell. Mr. Davis's attorney, Mr. Eddie Fayol, was present. The interview was considered a proffer agreement between the United States government and Mr. Davis, under which any information provided by Mr. Davis would not be prosecuted related to that information. Mr. Davis was repeatedly questioned about the alleged murder of Tupac Shakur. Mr. Davis denied knowing who shot Mr. Shakur. Mr. Davis was asked to speculate as to who shot Mr. Shakur. Mr. Davis stated it was the Compton Police Department under the direction of Suge Knight, owner of Death Row Records. Mr. Davis was asked what would be Mr. Knight's motive, And Mr. Davis responded Mr. Shakur was getting ready to leave working with Death Row Records. At no time during the interview, less than 2 years after Mr. Shakur's shooting, did Mr. Davis state that he or members of Southside Crips were involved in any manner with the shooting of Mr. Shakur. Okay, goes to an issue of credibility. Well, Davis says he was interviewed again in 1999, and during that meeting, he denied that his nephew Anderson was the shooter. Mr. Davis stated that Mr. Anderson was not involved in the shooting of Mr. Shakur. Mr. Davis did discuss that Mr. Anderson was attacked by Mr. Shakur in Las Vegas the night of Mr. Shakur's shooting. Nevertheless, the decision was made to retaliate in Compton since there were so many police around in Las Vegas during the Mike Tyson fight. And during that interview, Davis blamed Compton police for spreading the rumor that Anderson had shot Shakur, although later we know that Davis himself would say that in public statements. But the motion to dismiss also says that Davis was offered immunity during the Biggie Smalls investigation in the early 2000s. The filing reads, the 3 LAPD and FBI agents were part of a task force to solve the shooting of rapper Notorious B.I.G., also known as Biggie Smalls, legal name Christopher Wallace. The task force, through a sophisticated criminal investigation, obtained sufficient evidence that would prove Mr. Davis was the leader of the Southside Crips and his gang was responsible for over 360 kilos of cocaine and PCP. Mr. Davis provided 3 interviews to obtain immunity from prosecution. The final interview were solely questions regarding the Tupac Shakur shooting, which Mr. Davis was also provided immunity from prosecution. So during a December 2008 interview with investigators, that is when Davis allegedly started to spill the beans about his one-time friend, Sean Combs, who he refers to as Puffy. He claims Sean Puffy Combs solicited Mr. Davis to kill Suge Knight and Tupac Shakur for $1 million. Eric Zip Martin, an associate of Puffy Combs, provided Mr. Davis with a gun to exact revenge on Tupac Shakur for the beating Mr. Anderson received. Now, Davis reportedly told the investigators that even though the job had been partially completed and Shakur was killed, neither he nor Anderson ever got paid. He later revealed that he believes Combs had paid the go-between Zip Martin, who he claims kept the money for himself. And he said much of the same thing in a 2009 interview a year later, because according to the motion to dismiss, the Las Vegas Metropolitan Police Department, as far back as 2009, was in possession of the same set of facts that the Clark County District Attorney is now alleging makes Mr. Davis responsible for the murder of Tupac Shakur. The Clark County District Attorney's Office has offered no reason as to why it waited another 14 years to prosecute a case against Mr. Davis. Mr. Davis has been irreversibly prejudiced by this unnecessary delay in prosecution of this case, and Mr. Davis's constitutional rights have been violated in an extraordinary manner never before witnessed in the annals of the American criminal justice system. Now, of course, there was a response because the prosecutors from Las Vegas called out Davis for being quite dramatic and said he has been telling on himself for decades. So their motion in opposition to the motion to dismiss states, in the years following Shakur's murder, defendant Dwayne Keefe D. Davis confessed to being involved in Shakur's murder in nearly every form imaginable. Defendant confessed to some of his role in Shakur's murder during an interview with LVMPD Homicide in 2009. Defendant admitted to seeking a deadly confrontation with Knight and Shakur in interviews with the producers of the Death Row Chronicles in 2017. Defendant recounted his involvement in Shakur's murder in his book published in 2019. And defendant has gleefully claimed responsibility for the murder of Shakur in numerous YouTube interviews from 2019 up until his arrest. And the prosecution then addressed the issue of immunity from prosecution, right? Well, maybe he's admitting everything because, he thinks he's immune. They have a response to that. Quote, defendant asserts that he has received immunity from prosecution in this case. Defendant has provided absolutely no proof that transactional immunity was ever conveyed by any prosecuting authority. Defendant has provided no federal court order conveying immunity. Defendant has provided no California court order conveying immunity. However, even if he had such a grant, they couldn't possibly cover his criminal liability in Nevada. Defendant also claims that his proffer in 1998 and his statement to Detective Long somehow created immunity for the crime. As the court is aware, the legal community utilizes proffer to describe a contractual relationship between an interviewee and a prosecuting authority. In essence, a proffer agreement allows for statements made pursuant to the terms by the interviewee to not be used against that person. The state does not seek to utilize the 1998 proffer session against defendant, and has no idea what the terms of such an agreement were between him and the federal government before he entered his plea. The report seems to reflect that this was a standard proffer where a criminal defendant is interviewed about his knowledge on all possible criminal subjects he may have information about before he's allowed to enter his plea. While he doesn't refer to the proffer agreement with the AUSA Searwright, the terms of that agreement are known. Defendant was specifically informed that this agreement was between him and the federal government. Moreover, the agreement is limited to a single date and time. It allows for the statements to be utilized on cross-examination of defendant if he ever testifies differently. Finally, the agreement is limited by its express terms. Nothing in that agreement suggests the defendant has immunity from any criminal charges. Notwithstanding, it appears to only apply by its express terms to an interview on December 1st, 2008. Certainly, defendant is free to litigate the admissibility of the December 18, 2008 statement. However, case law establishes that defendant's mistake of fact about its admissibility, particularly where he had a lawyer present who knows the specific terms of the agreement, would not lead to suppression of the statement, meaning it can't come into evidence. And on Tuesday, Clark County District Court Judge Carly Kearney agreed with the prosecution, saying Davis has provided no proof that he had any immunity deals. And we're going to expect to hear in the next few days if Davis's legal team plans to appeal that decision to the state Supreme Court. Remember, going back to Cosby, it was the Pennsylvania Supreme Court who ultimately determined that his conviction should be vacated because he had entered into an immunity agreement. So we shall see what happens. Davis says he eventually became a confidential informant to a task force that was investigating the murder of Biggie Smalls. So this is Shakur's main rival at Bad Boy Records out in New York. And we know that Biggie Smalls was actually gunned down in Los Angeles. But prosecutors countered Davis's claims by saying there's no proof of any sort of immunity offer here, and that even if Davis had been offered some kind of protection from prosecution in California or the federal court system, that wouldn't apply to his case in Nevada. And the judge agreed, opting not to throw out the case, denying the defense's motion. One of the most interesting things to come out of that motion to dismiss, though, is just how many times Davis talked about Sean Diddy Combs over the years, the disgraced rapper and music mogul that we have been focusing upon a lot here on Sidebar, currently in a detention center on federal charges of sex trafficking and racketeering and prostitution, headed to trial out in May. But I want to talk about what Davis has to say about him, what he has to say about, I should say, Puffy. That's one of the many monikers that Combs has adopted over the years, and that's how he refers to him in this filing. So Combs started his meteoric rise to stardom in the early 90s as well. Started Bad Boy Records, now Bad Boy Entertainment out in New York. There was the big East Coast, West Coast beef, Death Row versus Bad Boy. And Davis says that Combs used that as an excuse to put out a hit, an assassination order on Tupac Shakur and Suge Knight. So let's take a look at what Davis had to say about Combs and a little bit of note about this. So Davis has told many versions of his story to police over the years, changing some details, leaving other details out. We got to take that with a grain of salt about his credibility. Sometimes he would admit to things, sometimes denying them. Again, just take that for what it is. In fact, I will also tell you, the state talks about that in their opposition to the motion to dismiss, which says on December 18th, 2008, defendant was interviewed by task force officers at his lawyer's office. This interview was surreptitiously recorded by LAPD Detective William Holcomb. During this interview, defendant confessed in detail about his involvement in the murder of Tupac Shakur, consistent with his book and subsequent YouTube.com statements. And what Davis revealed in an interview with the Art of Dialogue YouTube channel in 2021 is that his nephew, Orlando Anderson, shot Shakur from the backseat of the rented Cadillac. But during an interview with the FBI in 1999, Davis apparently said something completely different. According to the FBI report, which was included in the motion to dismiss, Anderson was not involved in the shooting death of Tupac Shakur, and neither Davis nor his group killed Shakur or Christopher Wallace, aka Notorious B.I.G. Davis does not know who killed the two rap stars. He believes that either individuals from New York associated with Puffy Combs or individuals associated with Death Row Records could have killed Shakur, and that individuals associated with Death Row Records killed Wallace. Okay, so again, changing stories. And by the way, Davis goes on to say that he was introduced to Combs in the early 90s by a man named Eric Zip Martin. This is another alleged drug dealer. And this is where we get into it. So the report reads, in or around 1992, Martin introduced Davis to Sean Puffy Combs. Davis recalls the introduction occurring at the Paradise nightclub on Santa Monica Boulevard. After speaking with Combs, Davis agreed to allow Combs to use his 1964 Chevy in a music video. The video featured the artist Usher. After the vehicle was damaged in the production of the video, Combs paid $2,500 to have it repaired. And by the way, according to Davis, Combs was scared of Suge Knight. And this was a man who had a reputation for being, sometimes violent and extreme. And that moves us now to this DEA report. So there was a DEA report from a 2008 task force meeting with Davis that was also included as an exhibit in the motion. And in it, Davis talks about the murder of a man named Jai Robles. This is Knight's bodyguard. He was killed in Atlanta in 1995. And according to Davis, he'd heard a rumor that an associate of Combs had killed Robles. The report says Combs requested to speak to Davis and asked Davis if he thought it was safe for Combs to come to Los Angeles for a concert. Combs expressed his concerns about Knight and possible retaliation related to the Robles murder. Davis advised Combs that he would provide 40 or 50 tickets to the concert. Davis could provide an entourage. Combs agreed, and Davis and his crew, in fact, attended the concert in support of Combs. Davis recalls the concert taking place in Anaheim, California. It was at this event that Combs began to solicit Davis to kill Knight and Shakur. Combs asserted something to the effect of, "I'll give anything for those dudes' heads." Quote, at a later date, Dwayne Davis, Eric Martin, Corey Edwards, Sean Combs, and others met at Greenblatt's restaurant in Hollywood. Well, at the restaurant, Combs summoned Davis into the downstairs area. Combs again told Davis that he needed to get rid of Knight and Shakur. Combs offered Davis $1 million to handle the problem. Davis remembers Combs being very afraid of Knight. So after the car that Knight and Shakur were in was hit by a hail of bullets back in 1996, Davis says that Combs wanted to know if that was the result of him allegedly putting out a hit on Shakur. The task force report states, well, at the restaurant, Martin told Davis that Combs had called Martin and asked, "Was that us?" Davis asked Martin when he would receive compensation for the shooting. Martin told Davis he would get the money when he returns to New York. Additionally, while at the restaurant, Combs called Martin again. Martin then handed the phone to Davis. Combs again inquired, "Was that us?" Davis recalled Combs sounding elated at the situation. Again, this is all allegations, but quite an allegation nonetheless. Now, Davis reportedly told the investigators that even though the job had been partially completed and Shakur was killed, he nor Anderson ever got paid. He later revealed that he believes Combs paid the go-between, again, Zip Martin, who allegedly kept it for himself. So we mentioned a moment ago that an LAPD officer had recorded statements that Davis made in 2008. The state included a transcript of that interview in its filing. And in the transcript, WH refers to Wayne Higgins. This is Davis's lawyer during the interview. Q refers to the questions, and the A's are Davis's answers. Okay, so it says, WH, okay, now go on and ask whatever you want. Q, Puffy Combs. A, yeah. Q, does he play a role in this thing? WH, answer the question directly. Tell him what you think. A, did he play a role in this? WH, don't hesitate, just tell him. Question, yes. Answer, yeah, I think he did. And later in the interview, Davis said, yeah, I feel, I wish it would never ever, I wish I never met Puff Daddy, period. I swear to God. Question, yeah. Answer, he messed up my life, man. I was rich up and under the radar, all that, man. Question, that's all gone? Answer, it's all gone. Now, what about Combs' alleged involvement in the death of Biggie Smalls, legal name Christopher Wallace? Okay, this was a big one. Smalls was gunned down in a drive-by shooting out in Los Angeles in March of 1997. You might be saying, I thought they were friends, right? Anybody who followed this? We did a whole sidebar on this, but Gene Deal, a former bodyguard for Combs who has recently started doing interviews and offering theories on Combs' alleged bad behavior, now says the rapper could have been involved in killing Biggie. So Deal, who was reportedly Combs' bodyguard from 1991 to 2005, sat down for the documentary Diddy, The Making of a Bad Boy, that aired on Peacock. And according to him, Combs was acting weird in the lead up to Biggie's murder. He says in the documentary, the week in which Biggie was murdered, he was just acting real anxious and trying to get big at this party. And what was crazy was Big was telling people he had to be in London, but Puff was telling people he ain't going to London that whole week. You fast forward to the day of the party, and Deal says, I'm sitting up at the Beverly Hills Hotel, and I get a phone call. It's about 9 o'clock, and they say, Gene, get ready. We going to the Vibe party. I was like, we going to the party? We don't have no security. But according to Deal, tried to warn Combs this probably wasn't a good idea. I say, yo, Puff, I got some intel, bruh. He said, what? I said, yo, man, if we go to this party tonight, one of us is going to get killed. Somebody going to die because now we got East Coast, West Coast beef. He said, yo, Gene, I don't want to hear that S. So we all jump in the car. I was in a car with Puff. Big was in his own car. And the next thing you know, you hear pow, 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 pow. Biggie was shot 4 times, died right after arriving at the hospital. And according to Deal, Combs showed up at the hospital, seemed shocked that Biggie was dead. And we asked celebrity criminal defense attorney Brian McMonigal about this latest accusation against Combs, who's already facing these 3 federal charges related to the so-called freak-off activity. And again, he's facing dozens of civil lawsuits. But here's what Brian had to say.
I don't see this. This is a 30-year-old accusation. And it seems to me that it's getting to a point where Diddy's concerned, where it's dangerously getting to piling on in a way that I think might just help him. As I thought about this last night, once I saw the article in the Post and was referenced on the documentary, it seems to me that there are a lot of people now that are jumping on this bandwagon of making what I would say are baseless allegations against this guy. This one in particular just smells to me. Did this guy say any of this stuff over the past 30 years to anybody in law enforcement? Has there ever been any kind of a suggestion that he was involved by law enforcement? It seemed to me that he was in a close relationship with Biggie, and that if anything, he was on the other side of this East Coast, West Coast fight. So the one thing that I would say about it is just bringing this kind of full circle to this upcoming trial. They're going to be looking for things like this, the defense in this trial. They're going to be looking for accusations that are stretched. They're going to looking for moments that they can disprove things. And make no mistake about it, there'll be a few things like that, and hope that that'll give them the kind of strength and ability to diffuse perhaps as many of these allegations as they can where this indictment's concerned.
Now, to be clear about something, Combs has always denied any involvement in the deaths of Tupac and Biggie, and he certainly has not been arrested or charged in connection with their deaths in any way. As for Davis, we go back to him. It's going to be up to his attorneys to decide if they will appeal the judge's denial of their motion to the state Supreme Court. In the meantime, Davis has been denied bail, so he's going to be sitting in a Las Vegas jail until his trial, which is scheduled to begin in March. We'll keep our eye on it. Sean Combs' federal criminal case out of the Southern District of New York, where he faces charges of racketeering conspiracy, sex trafficking through force, fraud, or coercion of victim 1, and transportation to engage in prostitution. Trial currently scheduled for May 5th, 2025. I want to go back to the indictment because this is really where it centers upon it. So it alleges that Sean Combs and other members and associates of the Combs enterprise wielded the power and prestige of Combs' role at the Combs business to intimidate, threaten, and lure female victims into Combs' orbit, often under the pretense of a romantic relationship. Combs then used force, threats of force, and coercion to cause victims to engage in extended sex acts with male commercial sex workers that Combs referred to as, among other things, freak-offs. Freak-offs were elaborate and produced sex performances that Combs arranged, directed, pleasured himself during, and often electronically recorded. In arranging these freak-offs, Combs, with the assistance of members and associates of the Combs enterprise, transported and caused to be transported commercial sex workers across state lines and internationally. Freak-offs occurred regularly, sometimes lasted multiple days, and often involved multiple commercial sex workers. During freak-offs, Combs distributed a variety of controlled substances to victims, in part to keep the victims obedient and compliant. Sometimes, unbeknownst to the victims, Combs kept videos he filmed of victims engaging in sex acts with commercial sex workers. After freak-offs, Combs and the victims typically received IV fluids to recover from the physical exertion and drug use. And let's not forget that prosecutors allege that these freak-offs weren't just happening years and years ago. In one of their letters to the court, they wrote, indeed, since at least in or about January 2024, when the defendant was unquestionably aware of the criminal investigation, the evidence shows that he is engaged in multiple freak-offs some involving the interstate transportation of individuals to participate, has continued to use narcotics, and has contacted multiple witnesses. Now, I think there's a fair argument to say that Sean Combs' defense counsel isn't going to shy away from the term freak-off. They might accept, yeah, Sean Combs called these sexual encounters freak-offs. Yeah, they weren't with commercial sex workers, but maybe it was group sex, or maybe it was things that were filmed with him and a partner of his, but doesn't make it illegal. The way it becomes illegal is if you do bring in these sex workers, if there is some sort of force or fraud or coercion that is used, or there are narcotics that are used, and this idea that it wasn't on the up and up. But I think they're going to say it might be different from what you and I do, but it's not necessarily illegal. I want you to keep that in mind. And obviously, as you heard there are elements to the racketeering charge, this kind of idea that there was a criminal enterprise that engaged in all sorts of illegal activity. Sean Combs was leading it. The sex trafficking, again, you particularly moving people across state lines for commercial sex acts. There has to be an element of fraud or force or coercion. Combs' attorneys filed a letter asking Judge Arun Subramanian, this is the judge in the Southern District of New York who is overseeing this case, they are asking him to order the prosecution to electronically produce videos of the freak-offs to the defense. And the reason they want these electronically produced, the reason they want copies of these in their possession to review and analyze, and why they need the court to step in, is because they say that under the current protective order in this case regarding how evidence will be viewed and disseminated, the video evidence is available for inspection only, right? They have to go to a certain place provided by the prosecution in order to view these videos. They say that's not fair. And according to the defense, the federal prosecutors refuse to produce over these videos to them. But more importantly, and this is the key, Combs' lawyers write, we need these videos because they prove our client is innocent. Quote, having reviewed these videos, it is now abundantly clear that they confirm Mr. Combs' innocence and that their full exculpatory value cannot be investigated and used unless they are electronically produced. The 9 videos at issue are the so-called freak-off tapes with victim 1 that the government has repeatedly referenced, causing wild speculation in the media. Contrary to what the government has led this court and the public to believe, the so-called freak-offs were private sexual activity between fully consenting adults in a long-term relationship. Like many Americans in the privacy of their own bedrooms, they sometimes filmed their sexual activity. These videos unambiguously show that the person alleged in the indictment to be victim 1 not only consented, but thoroughly enjoyed herself. And we believe victim 1 to be Cassandra Ventura. This is Diddy's ex, who first filed that initial sexual assault lawsuit against Combs back in 2023. She was also in that infamous surveillance footage that was published by CNN months ago, where you see Sean Combs in a towel beating Cassandra Ventura, dragging her, kicking her. The filing goes on to say, quote, moreover, contrary to innumerable sensationalistic media reports, the videos do not depict sex parties. There are no secret cameras, no orgies, no other celebrities involved, no underground tunnels, no minors, and not so much of a hint of coercion or violence. So not only talking about the allegations in the indictment, but also all of the claims that have been made in the media as well. Now, far from the government's lurid descriptions, the videos show adults having consensual sex, plain and simple. At bottom, this case is about whether victim 1 was or was not a willing participant in her private sex life with Mr. Combs. The videos confirm that she plainly was. And the defense in this letter describes victim 1 in these videos as, quote, happy, dominant, and completely in control. They write, there is no evidence of any violence, coercion, threats, or manipulation whatsoever. There's no evidence that anyone is incapacitated or under the influence of drugs or excessive alcohol consumption. There is certainly no evidence of sex trafficking. That's what they say. They go on to write, the premise that freak-offs are inherently dangerous shows that the government seeks to police non-conforming sexual activity and that it assumes, despite all evidence to the contrary, that a woman's willing participation must have been coerced. So again, that idea of doesn't seem like they're shying away from these freak-offs, but saying, while the freak-offs might be unusual, they're not illegal. Now, the defense also says that they reviewed photographs that they say victim 1 allegedly sent to Sean Combs, and they too appear in their characterization, quote, to reflect entirely consensual sexual activity. And the defense also claims in this letter that these recordings corroborate what witnesses have told the government. And they don't really explain more about that, but that seems to suggest that these witnesses are going to be helpful to Sean Combs' defense. Maybe these are sex workers who were there and say, look, our opinion, Cassie consented to everything that was going on, or victim one consented to everything that was going on. Now, we actually spoke with criminal defense attorney Bradford Cohen about this, and he's represented celebrities like Drake, Lil Wayne, Kodak Black. And the question is, based on the defense's characterization, is this the end of the prosecution's case, right? Do these videos prove that Sean Combs is innocent? Is there anything more? Take a look.
I think it's interesting because, you know, from the very beginning of this case, I was saying, I think that the original tape showing the violence against Cassie, I think the original tape was leaked by her team to show that she is a victim and not a willing participant or a co-defendant. So I've been saying that for a long time. So to hear this, that, okay, we've seen these 9 videotapes, and these 9 videotapes kind of back up what we've been saying the whole time, that it's consensual sex between adults. It's an interesting thing to say, because I think that the videotapes are going to show that Cassie probably was engaging with another individual. The videotapes are probably going to show that it wasn't a hidden camera, maybe that she was making faces or saying something to the camera that confirms that it wasn't a hidden camera or someone's talking on camera. All those different things definitely help his case. Is it a smoking gun, as we say? No, probably not a smoking gun, because she's going to still say, listen, I was still under the control of Sean Combs. He was physically controlling me. He was mentally controlling me. That's going to be where she goes with this whole thing. And that's where that tape of violence comes in, to show that, yeah, it might have looked like I was doing these things on video, that I was a willing participant. But in reality, I knew if I was not a willing participant, then something else would have happened to me physically or mentally.
Now, you might be saying, well, look, the fact that the tapes exist, Jesse, that shows that Sean Combs is guilty, because the government alleges he secretly filmed these encounters and used it to blackmail victim one to stay silent, to do what he wanted. The defense, to do what he wanted. Well, the defense has an answer to that in their letter. They write, these recordings were not on Mr. Combs' devices and were not seized from his homes. Rather, victim one kept these videos on her own device for years and produced them to the government herself. Now, Bradford also had an interesting take on that as well.
If the defense had these tapes, or Sean Combs had these tapes, when the tape came out, or when the accusations came out that she was not a willing participant in this sex, you don't think those tapes would have been leaked? Like,
well, he would have gotten in a lot of trouble if he did that, right?
Well, before the charges were even filed, when she said, when she first hit him with the civil complaint, and in that civil complaint says she was not a willing participant, she was not involved in these things, all these different kind of accusations in that civil complaint, you would at that point say, what are you talking about?
He settled with her the next day. And if you're him, I don't want to release these videos of me, my private sex life. You know, he probably didn't want to.
No, but you could, there's a way you could leak it to make sure her version of events was questioned.
Now, in terms of the defense's argument for why they are entitled to electronic production copies of these videos, they argue that this is a form of exculpatory evidence covered under what we call in the law Brady, that the government has to turn over, that Combs has a constitutional right to properly prepare for his defense. He has a due process right. That's why he should have it. And they also cite the federal rules of criminal procedure, specifically Rule 16, which states in part, upon a defendant's request, the government must permit the defendant to inspect and to copy data that is within the government's possession, custody, or control, and that is material to preparing the defense. And here they argue that videos of the freak-offs, they are material because that's essentially the prosecution's central point in this case, the freak-offs. And they argue the government has not presented enough evidence to withhold the videos because this is not child pornography. This is not classified information. Now, the prosecution responded in a letter of their own to the court, and they didn't directly respond to the Rule 16 argument or what the tapes show, but they argued that the defense's letter violated the protective order that has been put in place by the court. that under the protective order, that no portion of the videos should have been filed on the public docket without being filed under seal or without the defense first conferring with the government as to the designation. And they said neither occurred. Quote, instead of conferring in advance or redacting all content related to the videos, the motion blatantly violated the protective order when it left unredacted descriptions and characterizations of material designated AEO, attorney's eyes only. And they argue this threatens the privacy of victims. And they are asking the court to remove it from the public filing and have it be refiled with redactions. Well, the defense responded to that in a follow-up letter. And they said, look, we will make the requested redactions, but they want the court to step in. And they want to be able to refile this with narrower redactions. Why? Because they argue that the government's request was way too overbroad, that the government, they already told everybody what all of this is about, that they have been quite explicit and specific about freak-offs. And they also argue that there is a presumption of public access here. This is about the government's key piece of evidence in this case, the freak-offs, and that Mr. Combs' trial rights are being compromised by not having proper access to this material. They write, indeed, the public can only have confidence in the conscientiousness, reasonableness, or honesty of judicial proceedings if the documents on which judges rely are publicly available. And they say the government provides no satisfactory or adequate reason for why this information needs to be sealed. And I want to read you this part in its entirety because I think this is really key to the defense's argument. So in their letter, they write, quote, while victim one may have privacy interests that justify keeping the videos themselves under seal at this stage, including details of the content of the videos, the fact that victim one was filmed while participating in the so-called freak-offs is public information. Indeed, the government has publicized that these were extended sex acts with male commercial sex workers and elaborate and produced sex performances that were electronically recorded. The government has publicized gratuitous details, including the use of baby oil, lubricant, extra linens and lighting, room damage, and delivery of IV fluids. The government even held a press conference publicizing the seizure of more than 1,000 bottles of personal lubricant and baby oil. And the government has publicly asserted that during the freak-offs, alleged victims were subjected to physical, emotional, and verbal abuse, including being hit, kicked, and dragged, and that alleged victim claims are corroborated by videos of the freak-offs. Faulting the defense for characterizing that same evidence as exculpatory and consensual is an unfair double standard and demonstrates the government's intent to mislead the public and the court. To accept the government's broad reading of the protective order would turn it into a tool to shield the public from any interpretation of the evidence that could be favorable to Mr. Combs, after the government has been able to tout its own inculpatory interpretation. The result will be an unfairly polluted jury pool manufactured by the government's misleading narrative and widely disseminated by the press. So the question becomes, how much will be revealed about these tapes either before trial or even during trial? And you wonder how much a jury will be sitting there being shown these tapes, looking to see if there's illegal or consensual activity going on. And also, by the way, what's the reporting going to look like from inside that courtroom, right? No cameras are going to be allowed, but the reporters will presumably be front and center watching these videos because there'll be exhibits during this trial, videos of the alleged freak-offs. But I think it is fair to say that the government is not and cannot, in order to prove their case, rely solely on the tapes of the freak-offs, right? They have to have more corroborating information, whether it's witness testimony, whether it's the victim's testimony. There needs to be more to show that this isn't just group sex, but that it was forced, that it was coerced, that there was an element of violence or fear, that these sex acts were done through illegal means for Sean Combs' pleasure. We'll see what happens. That's all we have for you right now here on Sidebar, everybody. Thank you so much for joining us. And as always, please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. Speak to you next time. We are entering week 4 of the Sean Diddy Combs criminal trial, and there is one name that has come up quite a bit. Not only someone who may know quite a few things about the rap mogul, but someone who may be the key to this whole racketeering case. Will Christina Coram, Combs' alleged right-hand woman, testify? And what could she say exactly? Well, we're going to dive into what other witnesses have said about her so far and her alleged role in this whole saga. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber. Hey, everybody, listen up. This is another Law and Crime legal alert. If you received Depo-Provera birth control shots or were later diagnosed with a brain or spinal tumor called meningioma, you may be eligible for a lawsuit. Morgan & Morgan is investigating claims that patients were improperly warned about this risk. It's free to check, takes just a few minutes, and you don't pay unless they win. So scan the QR code on screen, click the link below, or head over to forthepeople.com/LCDepo to see if you qualify. Christina Coram, Sean Diddy Combs' reported former chief of staff. Now, she might not have testified in his criminal trial as of yet, but she's got to, right? I mean, in a prostitution, sex trafficking, especially a racketeering case like this, where prosecutors allege that Combs operated this criminal enterprise that engaged in a pattern of illegal activities for his benefit, and that he used his company resources and his staff to carry out crimes and cover them up, Coram has to be a central witness who's going to testify for the government, right? Don't you need to explain the inner workings of this operation? Particularly if you charge Combs with racketeering conspiracy, right? This criminal agreement that he criminally agreed to further racketeering activity. He can't do it by himself. The natural question becomes, based on what has been said in court so far about Christina Coram, is she a co-conspirator who's now going to testify against him? Has she been granted protection to do so? And to think about that, his former chief of staff, someone who has been described as his right-hand person, testifying against him, isn't that going to be devastating? That is what we're going to discuss, and how she's already been brought up so many times in this trial so far. It is fascinating because the name Christina Coram has already come up quite a bit since the Combs legal saga began. She has been mentioned in several lawsuits against the rap mogul and even named as a defendant in some of them too. For instance, a woman named Ashley Parham filed a suit claiming she was violently gang raped by comedian Drewski, NFL star Odell Beckham, and violently assaulted with a remote by Sean Combs. And in that lawsuit, as far as Coram, it says, quote, defendant KK told defendant Diddy that she did not think giving plaintiff a Glasgow smile would be advantageous to the potential clients who they could sell plaintiff for sex to. Defendant KK then made a threat to plaintiff that they could ship her off anywhere in the world and that she would never see her family or anyone she knew ever again. There was also an accusation that Combs had forced Christina Coram to use a syringe to insert an IUD into Parham. And apparently, she and Combs argued over it, not over actually doing it, but that it wasn't going to work. Really weird allegation, but a serious allegation nonetheless. And that's not the only lawsuit that she's been named in as a defendant. She was named in another suit that was filed by a series of plaintiffs, and they claim that she, quote, aided Combs in his abuse of men and women and covered up sexual assaults. She was also reportedly mentioned in other lawsuits, like one that was filed by a former employee who claims that Coram would order him to clean up hotel rooms after Combs' wild sex parties. And maybe most famously, and the first time I personally heard of her name, was when she was named as a defendant in the lawsuit brought by Combs' former producer, Rodney Lil Rod Jones, who claims sexual harassment, violation of the racketeering statute. He claims Christina Coram manages the day-to-day of Combs' alleged criminal and sex trafficking enterprise, and basically made the allegation that she was like the Ghislaine Maxwell of this operation. Obviously, a reference to the associate of deceased financier Jeffrey Epstein. Ghislaine Maxwell ended up getting convicted of sex trafficking charges and sentenced to 20 years in prison. And by the way, I'll tell you what, as reported by The Hollywood Reporter, Combs seemingly highlighted Christina Coram in a 2021 Facebook post, writing, KK keeps everything in my life and my business running. She's been my right hand for the last 8 years and has consistently proven to execute and get S done. Don't know how I'd function without her. Now, a few months back, Coram released a statement that was published by USA Today, first reported by Rolling Stone, and she said the following: for months, Horrific accusations have been made about me in various lawsuits regarding my former boss. These false allegations of my involvement are causing irreparable and incalculable damage to my reputation and the emotional well-being of myself and my family. I have never condoned or aided and abetted the sexual assault of anyone, nor have I ever drugged anyone. The idea that I could be accused of playing a role in or even being a bystander to the rape of anyone is beyond upsetting, disturbing, and unthinkable. That is not who I am, and my heart goes out to all victims of sexual assault. I am confident that the allegations against me will be proven to be untrue. Now, to be clear, while those specific allegations in the civil lawsuits haven't come up in the criminal trial, she has come up in a lot of ways already during testimony in Sean Combs' criminal case, which again makes me wonder, will she testify for the prosecution? Is it possible that she can actually help the defense? Give an example. Give an example of an idea of how she's come up so far and her potential value as a witness. So Combs' former assistant, George Kaplan, testified about Christina Coram. Who did you personally report to when you were Mr. Combs' assistant? I reported to Christina Coram, who is the director of his office. Do you recognize the person in that photograph? Yes. Who is that? Christina Coram. The same Christina Coram you were just talking about? Yes. Do you know her by any other names? KK. What was her role within Combs Enterprises? She was the director of Mr. Combs' executive office. So what were her job responsibilities? She essentially ran Mr. Combs' life. And more specifically, with respect to the charges that Combs faces, remember prosecutors are saying that women like Cassandra Ventura were forced into elaborate, prolonged sexual performances known as freak-offs with commercial sex workers that happened in various places, in various hotel rooms, and that Combs had his people prepare the rooms and clean them up afterwards. So if we accept that these are essentially crime scenes, listen to what Kaplan said on the stand. Who usually instructed you to set up a hotel room for Mr. Combs? Either Mr. Combs himself or Christina. When you say Christina, do you mean Christina Coram? Yes. A lot more to get into. I want to bring in right now former Palm Beach County State Attorney Dave Arenberg, who hosts Legal AF, which is part of the Midas Touch Network. Dave, so good to have you on here. Am I wrong? She's got to be called. She's got to be called as a witness in this case, no?
Absolutely. I mean, when you said that she was referred to as Diddy's right hand, it was Diddy who said that. So yeah, she has to. And it is very telling that she has not been charged with any crime. Why do you think? I mean, if she is allegedly the Ghislaine Maxwell to Diddy in this case, why has she not been charged like Ghislaine Maxwell? Well, I would think it's because she's already cut a deal with prosecutors. Otherwise, I think it'd be game on and she would be in the prosecutor's crosshairs. So I do expect that she is cooperating, at least in some way, with the prosecution. And I do think she will appear at trial.
How do you think specifically she would prove racketeering or help prove racketeering or criminal enterprise? How would she prove the sex trafficking of Cassandra Ventura? How would she help prove transportation to engage in prostitution, transporting alleged victims and sex workers with the intent that they engage in prostitution and sex work? What are some of the things you think she'd be called to testify about?
When you have to prove racketeering, you've got to prove an ongoing criminal enterprise, not some ad hoc thing that you do with your friends and acquaintances, an enterprise. Well, if you're going to say that Diddy's record company is part of this criminal enterprise, you have to call employees of that company. Who better than Diddy's right hand? She knows, metaphorically speaking, where all the bodies are buried. So when it comes to racketeering, whether there were two predicate crimes, she can provide evidence. She can provide evidence that this is an ongoing criminal operation. And yes, she can provide evidence on the other count of human trafficking to show that Diddy allegedly harbored, transported, in other ways, created this system of force, fraud, and abuse that led these individuals like Cassie to perform sex acts for money. And that's what happened. When you talk about human trafficking, it's a commercial sex act and you need force, fraud, or coercion. Well, that's what we're talking about here. And that's the evidence that this witness can provide.
So it came out during testimony that Homeland Security, HSI, they seized a cell phone of Christina Coram on September 16th, 2024 at the Park Hyatt Hotel when Combs was ultimately arrested. That's got to be quite telling and very interesting piece of evidence.
Oh, man, you don't want the authorities to have your phone, right? The phone tells all. I mean, so many cases we've seen where there are new charges that come after the authorities get your phone. And so, yes, so you think you would have to assume that the authorities know everything that KK knows. That's what Diddy calls her. And that's why the fact that she has not been charged tells me that she has been cooperating. She could be called as a rebuttal witness by the feds, or she could, as you said, and perhaps she'll be called as a defense witness. That is perilous, though, because if she lies on the stand, that could result in a perjury charge. Even if she cut a deal with prosecutors for immunity, that doesn't cover perjury. So it is a minefield if you call her to the stand as part of the defense. I think perhaps the prosecution has her lying in wait in case they need her as a rebuttal witness.
So I'm going to get into a minute all the times or a lot of the times that she was mentioned already in testimony and kind of give us a preview of what she might testify to and how she might be used by the prosecution and the defense. But real quick, as a point of law, the allegations that she's facing in the civil lawsuits, whether she's named as a defendant or not, you think any of that is going to come up in the criminal case against Sean Combs?
Well, it could. I mean, it's fair game if she's called to the stand. The accusations against her can come in. I mean, if she testifies against Diddy, Diddy's people can tear her apart by pointing a finger at her. They can try to make her into the bad guy, into her as the one who is trying to save her own hide by coming up with these lies. She's the one being sued, and she's going to say anything to get out of it. So that's the kind of thing you could see if she does turn on Diddy. On the other hand, the fact that she's been sued by various people and with really salacious allegations, yeah, that is something that's going to hang over her head. And that is something that Diddy can use against her if she is called by the prosecution as a rebuttal witness.
I want to talk a little bit about how she was already brought up during the course of this trial. So I mentioned George Kaplan. So he testified that he was a witness to the abuse of Cassandra Ventura, victim number one in this case. Prosecutors say that Combs used violence, threats, financial control, intimidation, manipulation to coerce her into commercial sex acts, right? Sex trafficking. And Kaplan said that one time he was on a private plane, heard glass shattering, and he sees Sean Combs holding up a whiskey glass over his head. Cassie's on the floor. Her hands are in front of her face. He also said he observed Combs throw green apples at another girlfriend of his in his Miami home. So this pattern of abusing women, important for racketeering. And this is the back and forth question. What did you tell KK? I gave her a recount of what I had observed the night before. Did you tell her everything you have just told us? Yes. What, if anything, did you tell her about what you had observed on the jet involving Cassie? I had told her each time that I witnessed any sort of violent act. Did you tell KK about the incident on the jet? Yes. Do you remember being asked about the conversation you had that next day with Christina Coram? Yes. Did you tell her about both of these incidents during that conversation? No. Which incident did you tell her about? The green apple incident. And earlier, had you told her about the incident on the jet? Yes. What did you tell her about why you decided to quit working for Mr. Combs during that conversation? I think the words I used were that I was unwilling to stand by the behavior. What behavior were you talking about in the context of that conversation with Christina, the green apples and the airplane incident? Did you tell Christina you were going to quit because of that? Yes. Did Christina say she was going to quit too? No. Did Christina, as far as you know, quit any time after you left? No. As far as you know, how long did Christina stay working for Mr. Combs after you told her about these two incidents that shook you tremendously? I haven't spoken to her in a while, but my understanding was that she was working for him up until pretty recently. Dave, what does that tell you?
Tells you, allegedly, she was in on the whole thing. I mean, she seems to be the one employee that hasn't broken from Diddy, that hasn't been attacked or threatened. And why is that? Because allegedly she has been carrying out Diddy's criminal enterprise. That's what the government, I'm sure, believes. But why hasn't she been charged? Because she knows so much she could sink Diddy. So I think that's why. Or maybe if they haven't cut a deal with her, they're waiting to charge her afterwards, like Ghislaine Maxwell was charged afterwards, but after Jeffrey Epstein. But I think it's more likely that a deal's been cut. I mean, some of these allegations are crazy.
And the jury would know about that? She'll be asked about that, right?
About whether she cut a deal with prosecutors? Oh, yeah. That's always used by defense lawyers to undermine the credibility of a witness, saying, oh, you're here under immunity agreement, right? You know, you cut a deal with prosecutors, right? You're facing decades in prison, and that's why you're here lying on the stand. That's the kind of stuff. By the way, it doesn't mean she's lying. It just means that she's thinking about herself. That's human nature. Yeah. I just had to say, all these incidents, I mean, how can Diddy survive in the court of public opinion no matter what happens here? I mean, you have the green apple incident.
Well,
I mean, I actually just had to Google the Glasgow smile. I didn't even know what that was.
So that allegation, right, was from one of the civil suits. I mean, look, the court of public opinion, I don't think there's a way for him to recover. The the actual criminal trial, it does become a question. Does it amount to sex trafficking? Does it amount to racketeering? I could play both sides here. I could do a whole analysis back and forth about whether or not at this point in the trial the prosecution's proven or not. I think they convinced he might not be a great guy. He might have abused people, but does it amount to a criminal enterprise? And that's why I think Christina Quorum may be an important witness. By the way, Cassie Ventura also testified about Christina Quorum too. Listen to this exchange. When you mention trusted assistants, who were some of the trusted assistants? I mean, in the very beginning, it was David James. It just kind of changed over time. Christina Quorum, eventually, Neil Dominic, he had a lot of different assistants. At what point in your relationship did you start communicating with Miss Quorum? As soon as she started, I'm not positive the year. Was that in the beginning, the middle, or the end of your relationship with Sean? It was like the middle of the relationship. What did you call Miss Quorum? I called her KK. And how frequently did you interact with KK? Every day. And what subject matters did you communicate with KK about? Everything from scheduling to what kind of mood he was in. I talked to KK about a lot. She knew a lot of my personal things. Aside from conversations you had with your attorney, which I don't want you to ask about, was there any other way you went about trying to contact Sean regarding the book chapters? By the way, I'm taking different pieces of the testimony, but this is, I believe, was about Ventura allegedly offering Combs the rights to her book about her experiences, about her time with him, possibly that he would buy them for $30 million. Well, anyway, Ventura responded, yeah, I reached directly out to Christina, to KK. What did you ask KK? I asked if he had read it and or just knew about it at all. And she said that basically it hadn't been taken seriously. Like, I don't think anybody believed that that was actually me. So what do you mean you don't think anyone believed that was you? She said it wasn't taken seriously. Like, they didn't think that I would do something like that. Then, by the way, she testified about an episode where Combs had allegedly tried to get into her apartment. So listen to this exchange. Ms. Ventura, how do you know Sean was trying to get into the apartment? Because I was notified by his assistant. Who told you Sean was trying to get into your apartment? Well, Terry, because she was there, and Christina Quorum. What, if anything, could you hear while this was happening? Just chaos outside the door, banging, kicking, yelling. So, Dave, according to Ventura, Quorum was essentially in the thick of it all. And it does make you wonder, you know, exactly, does she corroborate Cassandra Ventura's account, and how much is she going to be grilled about this? Again, I think a central role she might play.
Yeah, the big defense for Diddy and all this is consent. He's trying to make jurors believe that Cassie and the others consented to this activity. And if you can prove or at least show some doubt that there was consent here for that alleged human trafficking, then the whole case falls apart. So how do you combat that if you're Cassie? Well, you have corroboration. You have other witnesses who have testified, but also you have contemporary statements that she made to KK. Statements that said, here, this is what's happening. This is what's happening. And that kind of stuff's important because it shows that Cassie was being forced into it or was being coerced into it. And any statement she makes at the time can come in to show her present sense impressions that she was thinking like this at the time. This was her spontaneous comments, and it shows that she was under duress, that it was not consensual. So KK is valuable for a lot of reasons. And that's why I guess maybe I'm a little surprised she has not been called yet by the
Let's talk about that.
But that could happen. Yeah.
I think it was strategic because other people have already testified about her too, right? And I think it's strategic on the part of prosecutors to not call her yet. Why do I say that? Deontay Nash, this was Combs and Cassie's stylist, took the stand. Question, who on Mr. Combs' staff did you talk to about the violence you observed Mr. Combs inflict on Cassie? Derek and Christina. Who is Christina? Puff's assistant. How did Christina respond when you told her about violence you observed between Mr. Combs and Cassie? That she would talk to him. Then there was an objection. The court overruled it. And did the violence stop after she said that? No. You said he would blow everyone's phone up. Who's the he? Puff. And when you say blow everyone's phone up, what did you mean? He would call incessantly. Who did you see him call incessantly? Me and Cassie. And who else during those same periods called you and Cassie? Christina. Christina Quorum? Yes. Did you answer any of those calls? Yes. When you answered Mr. Combs' calls, what did he say? He would just say, we needed to get back to the house. She needs to get back to the house. And And what do you remember his tone being? Sometimes angry, sometimes he would soften up. And what do you remember Christina saying when you answered her calls? That she was going to help with the situation, that he's calmed down, that we should come back to the house. Then there was Ventura's former friend, Kerry Morgan, who testified about Christina Coram. Question, why would Miss Coram tell you she was trying to call you if he couldn't get in touch with Cassie, usually? Did she ever tell you who had told her to call? Well, I'm assuming it would be Sean. Without assuming, did she ever say that he had told her to call? Yes. And she testified about this alleged encounter when Combs allegedly showed up to Ventura's home, pounding on the door with a hammer. This, by the way, was after the infamous 2016 hotel video of Combs appearing to beat up Cassandra Ventura. Morgan testified police were called after Combs couldn't get into the apartment. Quote, who, if anyone, did you tell about the police officers arriving at the apartment? Christina Coram. Miss Morgan, do you recognize the participants in this chat? Yes. Who are they? Me and Christina. Could you please read your first two messages? I'm so sorry I missed your calls. I'm just so not used to this S. Are you okay? And then the first two messages on the next page. It's so dramatic. I haven't been looking at my phone. We're okay, but it's just so nuts. Okay, turning to this next message, can you read it, please? I don't think anyone should call her. Who is the her you're referring to? Cassie. Did you send an attachment with this message? Yes. What was that attachment? It's the card that the detective left. I'll read Miss Coram's messages if you read your own, please. Can I call you in a bit when I'm alone? She was looking for anyone to say the wrong thing so she can call domestic abuse. Who is the she that you're referring to in this statement? The police officer that came? Okay, turning to the next messages, could you please read? Of course. Cass just asked me to send you that. And what were you referring to when you said Cass just asked me to send you that? The business card of the detective. In these messages, Miss Coram mentioned she is going to call you. Did you talk with Miss Coram on the phone after this? I'm not sure. Mia, Combs' former assistant, Mia took the stand, testified that Combs physically and sexually assaulted her. And she, too, testified about how Christina Coram was in the thick of it, the knowledge component, alleged cooperation or facilitating this. So Coram would contact her, allegedly, when Combs wanted to get a hold of her. Again, alleged victim number 4. But it's interesting. For example, Coram allegedly messaged her, he just called me again, and he said he needs you to call him now. I told him everything you said, and he does not want to listen, and said you need to call him now. Mia, I'm sorry. I don't know what else to do. Mia, he just told me to tell you if you don't call him in the next 2 minutes, you don't have a job. Dave, is Coram a reluctant co-conspirator for racketeering conspiracy? And by the way, strategic, I think it was strategic to bring her up so much for the jury that when she finally does maybe testify, the jury is very familiar with who Christina Coram is. So 2 points there. Do you think she's a reluctant co-conspirator? Because again, racketeering conspiracy, he can't be it himself. Or and was there this ambivalence? And again, I think the strategic point of it was the jury's going to recognize her when if and when she testifies.
Yeah. Well, at times she does appear to be a reluctant co-conspirator, like that last email you read. But at other times, she seems to eagerly try to cover up for him and really enable him. So, yeah, it just depends. You can get her both ways. You can get her as someone who was full-fledged in on the racketeering, and other times that she was had a conscience and she was reluctant to go along, but she ultimately did. Either way, you got her as part of the conspiracy, the racketeering. You know, you could have done it either way. You could have brought her in after all the other people testified because they all corroborate each other. So if she goes up and lies, she'll look really bad, and it could blow back on the defense and say, oh, this is the employee covering up, and then you could always charge her for perjury. But there is value, as I'm saying, calling her a rebuttal witness. It's like the sword of Damocles hanging over Dave's head. You want to play? You want to put on some lies on your defense? I got ace in the hole. I got that sword of Damocles. I've got KK will come and just corroborate everything Cassie said and undermine everything you said in your case. So you better be careful what you say in your defense.
Before we wrap things up, I have to talk to you about what I think the defense might do with her, right? And whether or not she'll be called by the defense. Seems unlikely. Seems like she'd be called by the prosecution. But if you go back to the cross-examination of these witnesses by Combs' defense attorneys and how these people were questioned specifically by Combs' attorneys about Christina Coram, I wonder if it gives us kind of a preview of how they might use Christina Coram for their benefit if she testifies. For example, George Kaplan, this was cross-examination, explaining who Christina Coram was. She was my immediate boss. Certainly in the first 6 months that I was there, she told me what to do and when to do it. I learned how to do the job very much from her guidance. I talked to her more than I talked to any other individual on the staff. We certainly bonded over the amount of time that we spent together, which was many hours in different locations and late nights and things like that. You said that at some point you spoke to Christina about the violence that you saw, correct? Correct. And if I remember your answer right, I think you said that Christina was disappointed and saddened, correct? And that's what she expressed to you in the conversation you had with her, right? Correct. And she was disappointed in Mr. Combs. Is that right? Yes. As were you? Yes. You and Christina had a conversation when you said, this is what I saw. You told her what you saw, and you were disappointed, and even more than disappointed. I was sad. You were sad. And part of the reason you were sad, and tell me if it's right, I'm sorry for doing this way, because it's sad, right? Yeah, it's horrible. Then there was this cross of Kerry Morgan. KK was Sean Combs' chief of staff or personal assistant. She was with him all the time. She took care of she was like his right hand, basically. She's a good, really nice girl. Question to Morgan was, did you have your own relationship with KK? I did. And tell us about that. About a relationship? Yeah. It wasn't, we would only see each other when she was working or when I was hanging out with them, but we would hang out at Burning Man and stuff. She was there. We would hang out. We weren't that close, but understood. You said a minute ago that she's a nice girl. Just tell us more. She's a nice girl. She always seemed very innocent, and she's always trying to help everybody. She was always nice. I think that's deliberate here, Dave, right? I think it goes to the idea of this was all domestic violence. She didn't approve of it. She had no choice but to, do what Sean Combs wanted, but it wasn't necessarily a crime. She's a good person. Is that what you're getting from this cross?
Yes, and it is interesting in this case how both sides are working off largely the same facts. There's not too much of a dispute over the facts. It's just how to interpret them. On the defense, they're saying, yeah, Diddy was a bad guy. He was jealous. He is a domestic abuser, and so he should perhaps be charged in state court. But this is a federal trial, not on domestic abuse, but on racketeering, on human trafficking, on prostitution. Those charges don't apply. And here's the evidence, as we're going to interpret it, that proves this. This is a case of a jealous guy who had issues and committed some bad acts, but it wasn't human trafficking. It wasn't racketeering. That's the defense. On the other hand, the prosecution can paint this larger picture of a guy who's out of control, who ran this whole enterprise to do his bidding. And that included KK. That included force, fraud, and coercion for human trafficking. That included prostitution. And yes, it included racketeering through at least 2 predicate acts. We saw the Kid Cudi arson. We've seen the witness intimidation. We've seen the extortion, all these acts. So pick your poison, guilty.
I think the defense is basically saying there was no criminal agreement. She didn't agree to further any of this illegal activity. She didn't further sex trafficking operation, right? This idea was she didn't approve of any of this. She didn't condone any of this. I think that's what they're going with. So it'll be very interesting to see if Christina Quorum takes the stand. She's already been mentioned so many times. Dave Arenberg, thank you so much for taking the time, sir. Good to see you.
Thank you, Jesse.
And that's all we have for you right now here on Sidebar. Everybody, thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you get your podcasts. I'm Jesse Weber. I'll speak to you next time.
Okay, guys. I'm sorry. Let me end this live. Hey, guys. I am back.